You be seated. Good afternoon and welcome to the Appellate Division. I'm about to call the calendar and I'm going to assign the times that you will be allotted for your argument. I can only say that everybody must be excited to be here in person again because we have 20 cases that are here to be argued this afternoon. As a consequence, I'm going to ask that when you request time, please only request the time that you actually need. The first case is People versus Pinkston. All right, 5, 2, and 5, thank you. Wiggins versus City of New York. 7, 2, and 7, thank you. H. Children. Submitted. De Diaz versus Klausner.
Good afternoon, Your Honor. For Appellant, 5 and 2, please.
5, 2, and 5, thank you. People versus Darrell Robinson is submitted. Solomon Capital versus Lion Biotech.
Good afternoon, Your Honor. For the appellant, 5 minutes and 2 minutes. For rebuttal, thank you.
Good afternoon, Your Honor. For the respondent.
5, 2, and 5, thank you. People versus Anthony Hernandez. Submitted. Dimitro versus Dormitory Authority.
For the plaintiff, the appellant respondent, 6 minutes and 2 rebuttal.
Defendant and appellant candidate, 2 and 1, please. For defendants, respondents, dormitory, opus, and center, 2 and 1, please.
For Respondent, Appellant Martin Association, 2 and 1, please.
Good afternoon, Your Honor. For respondent, appellant
Which respondent was, which party are you representing? You requested also 2 and 1? Okay. I'm going to give you 2. Okay. Anybody else? All right. All right. So the plaintiff, you'll get 6 and 2. The remainder of the parties, you'll get the 2 and 1 that you asked for, except for the last party, you'll get 2 with no rebuttal. All right. Lauren versus 50 Madison.
Good afternoon. For Appellants, 6 and 2, please.
We have a respondent here.
Respondent, 6, Your Honor.
5, 2, and 5. People versus Gordon Francis.
Good afternoon. Appellant request 5 and 2, Your Honor. Respondent request 5.
5, 2, and 5. The next case, Florentine O versus Benoit G. Submitted. CIT Group versus Star Surplus.
Good afternoon, Your Honor. Appellant, 7 and 2.
6, 2, and 6. People versus Alex Starts. Submitted. Williams versus Forward Realty. Submitted. Romero versus Valdez.
Plaintiff appellant, Your Honor, 5 and 2, please. Respondent, 5, please.
5, 2, and 5. Thank you. Ahmed versus O'Neill is submitted. Ladder Capital versus Portfolio Hotels.
Good afternoon, Your Honor. Appellate request 5 and 6, please.
5, 2, and 5. Thank you. People versus Jalil Shakur.
Afternoon, Your Honor. Appellate request
6, 1, and 6. Cabrera versus Liberty Elevator Company. Submitted. People versus Brown. Submitted. People versus Jason R.
Appellate request 5 and 2, Your Honor.
Appellate request
5, 2, and 5. Zhang versus City of New York.
For the appellant, Your Honor, 5 minutes.
And you'll be the only one appearing. Apparently, your adversary has withdrawn their request. So I'll give you 5 minutes. Okay. Niesman versus Mount Sinai West. Submitted. Right, the first case called on the calendar, People versus Pinkston. Step up, please. You may proceed.
Thank you. Good afternoon, Your Honors, and may it please the Court. I am Ralph Franco with Jonathan Rosenberg's office for the appellant defendant Anthony Pinkston. Your Honors, I'd like to spend the bulk of my time discussing point 1 of our brief, specifically the mode of proceedings error, which invokes the Criminal Procedure Law 31030 and the Court of Appeals decision in People against Orama, which is 579 New York subsecond 189. Your Honors, this primarily centers around the failure of the trial judge to read verbatim the jury instructions into the record. As we point out in our brief, the judge...
Does it have to be verbatim, though, counsel? That's the question under Orama.
I'm sorry, Your Honor?
Does the recitation of the note or notes have to be verbatim under Orama?
That is my reading of the Orama decision, Your Honor. I believe that the language that the Court of Appeals cited, if I can quote, we conclude that, quote, meaningful notice in this context means notice of the actual specific content of the juror's request.
One can convey content, the actual content, without reading the note verbatim. Wouldn't you agree with that?
Your Honor, I think the underpinnings of the Orama case are that without the full question quoted directly into the record, defense counsel does not have the opportunity to, in essence, get the tone and the sense of what the jury is asking and contemporaneously have the opportunity to give input. And I think that is, in essence, the mode of proceedings error here, Your Honor.
And are you arguing mode of proceedings because preservation is lacking here?
Well, that is the people's position, Your Honor. The preservation issue does not apply, obviously, in a mode of proceedings context. It's a very narrow issue. But that very narrow issue, Judge, in this record is centered around precisely the conduct that is proscribed in Orama, which is, in essence, the judge improperly summarizing what the jury said. Parenthetically, Your Honor, the judge also put her thumb on the scale when she indicated in sum and substance that it was the defendant's cell phone records. That point had not been conceded, Your Honor. Now, the people will say that's because the jury note characterized it that way. But the court has the obligation to make sure that the proceedings are appropriate and that type of misconception or miscommunication, or in essence summarizing the evidence, not be made. So it's not a defense, I think, of the trial court to say that's the way the jury phrased the question, Your Honor. I think the underpinnings of Orama mandate that the exact language come in.
So wait, counsel, are you saying that if the trial court misses an or a the or some small preposition, it's a bright line rule and that's it? It's over, it's done? The note wasn't read in exactly as it was written, and therefore that's a motor proceedings error that requires reversal?
In short, Your Honor, yes, quoting right from the case, Orama.
No, I think
Indeed.
what Judge Moulton says is you have to have meaningful notice. It doesn't say you must read verbatim, does it?
Your Honor, I'm quoting directly from the decision. Indeed, the precise language and tone of the juror note may be critical to counsel's analysis of the situation in the jury room and the ability to frame intelligent suggestions for the fairest and least prejudicial response.
So your position is if I miss the word the or an that will change the meaning of the note and therefore automatically reversal?
Well, Your Honor, if we're giving the plain language of the Court of Appeals decision, it's clear that it says indeed the precise language and tone. So obviously, Your Honor, that's an extreme example of the word a or the, but again.
But that's what you're arguing for, correct? Is a bright line. You miss one or the, done, over.
This is what the Orama case holds with respect to that issue, Your Honor.
Assuming that we don't agree with that and that we think that the case says you have to have meaningful notice of what the jury is asking for, was there meaningful notice in this case?
No, there was not, Your Honor, because it's extremely unclear from the record. May I finish the point, Your Honor?
You may.
Thank you. It's extremely unclear from the record, Your Honor, the chronology of these events. The court summarized it. There was informal colloquy. It's unclear the exact timing of the note, all of the things we assert in our brief. It is not the jury has indicated in sum and substance and a direct reading of the quotation. And that is, I believe, what Orama and the criminal procedure statute requires, Your Honor. Thank you, Judge.
Good afternoon.
You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court. My name is Sheila Bautiste, and I represent the people in this case. Your Honors, defendants' Orama claims are unpreserved, and Orama does not even apply to this case. All of the notes that defendant objects to in this case were requests for exhibits. Those are ministerial requests from the jury that don't require the mandates of Orama. But even if you were to apply Orama to this case, defendants' claims are unpreserved. Orama requires the court to read the note to the parties, the precise language of the note into the record to the parties. The court then tells the parties how they're going to respond to the record, and then the parties have an opportunity to have input on the court's response, and then the court calls the jury into the...
Counsel, your adversary says that the trial judge her rendition of the jury notes did not provide reasonable notice pursuant to Orama, and I would add in People v. Mack. What do you say?
We argue that there was notice because in this case, for every single note read into the record, the judge read exactly what the jury wrote into the record. And that's what Orama requires. Orama requires the judge to read the precise language the jury wrote on the notes. And that's what happened here. We have the jury notes in the record. We have the transcript of what the judge said. So by that, by reading those notes into the record for the parties in the presence of defense counsel, that was the requisite notice that Orama requires. By doing that, defendants' arguments are unpreserved. But again, Orama does not even apply to notes that are requesting exhibits. And in this case...
Counsel, I'm not sure that's accurate because the first note also requested readback of testimony. So it just wasn't exhibits. It was also a request for testimony. Can you address that?
I agree, Your Honor. Thank you for correcting me. But I would also argue that is a ministerial request. The readback of a testimony is a ministerial request. The judge did read that part of the note into the record in conformance with ORAMA. Thus, defendant's claims are unpreserved and also without merit, since the judge in this case did exactly what ORAMA requires. There was one final note that wasn't a request for records, but as the record showed, we have the note and we have the transcript of the record. We have that the judge read this note into the record verbatim and gave notice to the parties, provided her response, and there was no objections to those responses that are the same as the ones raised on appeal. If the panel has no further questions, if Your Honor has no further questions, we ask that you affirm the conviction.
Thank you. Rebuttal?
Yes, thank you, Your Honor. The notes were very substantive, Your Honors. The court was, in essence, being asked for advice by the jury. They talked about, and I'm quoting, "Can you explain the balance between focusing on the evidence versus our gut feel, versus a piece-by-piece, also a holistic view of everything versus piece-by-piece when making a decision?" So they were asking the judge for advice. The court, in terms of summarizing what the questions had been, indicated in substance things such as, quote, "They want the testimony of Officer Fernandez," things of that. So the court, we can't see one passage in this record where the judge says the jury has asked us to question as follows. That is not a waivable argument, Your Honors, under ORAMA and the CPL. The fact of the matter is, not only did the court fail to read those instructions substantively, but in suggesting that it was the defendant's cell phone records and then summarizing the reasonable doubt charge in a way that was not true to the actual charge, that had the effect of putting the thumb on the scale. It's not waivable, Your Honors. It's not subject to harmless error. We're asking reversal on that basis. Thank you very much, Your Honors.
Thank you. Wiggins versus City of New York. You may proceed.
Good afternoon, Your Honors. Mark Walsh, Rosenbaum, attorneys for the appellant plaintiff, Reginald Wiggins. May it please the court. The instant appeal is seeking this court's review of its current precedent regarding general municipal law, where it has previously interpreted the same to establish a condition precedent that an individual must name individual municipal actors.
You'd actually, in essence, you want us to reverse our prior holding in Alvarez.
In Alvarez, Tenenbaum, and Cleghorn, yes,
Right,
Your Honor.
and its progeny. Well, no, progeny, I guess backwards. But so what gives us the authority? Under what circumstances would we not be bound by stare decisis and be free to otherwise reconsider this issue anew?
Well, Your Honor, in response to that, I think the decisions of the concurring opinions that affirmed Alvarez actually opens the invitation for my appeal here and today, where both decisions actually said that were it but for the facts, that the court should not act in a slavish manner to uphold a precedent which has otherwise become obsolete, or societal events have occurred that require its change. And to that extent, the court evaluated the facts before it in Alvarez. The court held that the city's ability to investigate the claims, while it has its own internal records that would afford it the ability to ascertain the involved police officers, that the plaintiff in Alvarez had likewise a similar situation. He was arrested and underwent a criminal proceeding and was acquitted on all charges within the same year, and his participation in that criminal proceeding afforded him an opportunity to be faced with his accusers and the police officers that brought charges against him.
Counsel, also, is it correct to say that there's been further judicial commentary since Alvarez, in the sense that there are opinions?
Yes, there's been...
Blake from the Second Department, a number of cases from the federal judiciary, is that correct?
Exactly, yes, Your Honor. There's been extensive decisions since Alvarez, the last time this court was able to hear on this matter, And all of those courts, the Second, Third, and Fourth Department are in harmony on this matter and actually have unfortunately held the First Department out as a sole contrarian. And the First Department's current precedent is simply not in harmony, is the appellant's position, because they haven't been given the opportunity to reverse. Likewise, the federal district courts, when they've been able to choose between the departments and which precedent to apply, have uniformly, as of late, adopted the Second, Third, and Fourth Departments, and some judges have gone as far as even opining that should this matter ever present itself to the Court of Appeals, that the Court of Appeals will adopt the Second and Third and Fourth Department's precedent. The reason for this is, going back to what I was saying on Alvarez, is
Counsel, has anything changed since Alvarez? Is there some change in either the world, or what's changed since Alvarez? Because obviously, we're bound by our own precedent unless something's changed.
Right.
What's changed?
Well, I don't know that the recent changes can account for the other departments' decisions because they predate it, but in most recent times, the obsolescence of the precedent is evidenced by the fact of the societal calls, the Black Lives Matter movement, and the police accountability movement. Recently, Governor Cuomo in the state of New York has even repealed certain protections that made certain police files as to when they were brought up on violations more public.
Can I interrupt you? Because the precedent that you're looking to, well, in this case, it does involve police conduct, it would apply really to any municipal employee, correct?
Correct.
So, why would, so I guess my question is that if the rationale is the societal changes are in the realm of criminal justice and how we view it, why would that apply to really an across-the-board rule that really deals with municipal employees in general?
Well, respectfully, the current precedent of the First Department, which allows for the dismissal if the individual is not named in the notice of claim, is most often utilized by the city or a municipality in instances involving police officers or something of that nature, because it is no secret the loss that is suffered by a plaintiff with not being able to include the individual municipal agents is punitive damages. And punitive damages would most often be sought and something that could be claimed against actions against police officers or prosecutors.
So you're relaying that anecdotally. You don't have any data.
I can only speak as my own experience as a plaintiff's attorney. I've initiated many lawsuits against MTA and bus accidents where obviously the driver was a municipal agent. That agent hasn't always been named in a notice of claim, and I've never had to appear before a
So,
court.
counsel, let me ask perhaps the same questions in a different way. So obviously, residents of Manhattan and the Bronx are in a different posture than residents of Staten Island and Brooklyn and Queens when it comes to notice of claims, right?
Correct.
They don't, if litigants in Manhattan and the Bronx don't name the individual police officers or municipal employees, they're out of the box, whereas the residents of the three other counties stay. So as to the issue of stare decisis, what is your position here? What is the difference between having the First Department reverse itself as opposed to referring this matter if there was agreement with your, well, let me change that. What's the difference between having the First Department reverse itself and and as opposed to affirming Alvarez and then sending the case to the Court of Appeals?
I think the significance of having the First Department reverse itself as opposed to having to go to appeals is the service that this court owes to the society in which it hears cases. It would allow this court to appear to be responsive to maybe the calls of society as of late, where there has been peaceful protests in the street, and those protesters at times have had conflicts and injuries resulting from police officers, but whether they protest in New York versus whether they protest in Brooklyn could have serious legal ramifications as to their ability to assert claims in the future. And I think the First Department acknowledging that this statute is in derogation of a plaintiff's right and to fall in harmony with the other departments makes it so that the statute cannot be wielded as a sword and shield or otherwise a trap for the unwary, as referenced in Sandak v. Tuxedo.
Thank you. You'll have rebuttal time. You may proceed.
May it please the court, Daniel Matson Brown for the respondents.
So turning to another point of this argument, before we get to stare decisis, why is Alvarez good law? Why would we follow that rule? Everybody else who's looked at this, other departments, and even the dissenting jurists in Alvarez say, this isn't good. Even one of the concurring justices in Alvarez did it on stare decisis. She didn't say it was a good rule of law. Why would we hold on to this?
Your Honor, I'm going to start by explaining my best defense of the Alvarez plurality. And then I think we can pivot to what Section 50E intends, which I believe is consistent with Alvarez, but I also believe that under any approach of any department, the city still prevails on this case because the notice of claim did not provide notice of any intent to litigate any police misconduct. So starting with Alvarez, Section 50E, if you look at the beginning at Section 1A, talks about notices of claim that are required for claims against city employees. And then if you turn to Section B, it talks about how the notice of claim has to disclose the nature of the claim. And I think that it is quite reasonable to say that if you have a claim against an employee, part of the nature of the claim is that it's against the employee. In this case, if we look at our notice of claim, it talks about 10 years of misconduct by correction officers and by prosecutors, especially prosecutors, right? That was the basis for the conviction to be vacated, was 6 years of delay. But there's nothing in the notice of claim about any police misconduct.
Counsel, there's also nothing in the statute that says anything about a requirement to name individual defendants in a notice of claim. The Fourth Department described, if I may be so bold, the First Department's position as a judicially required requirement. What say you?
Your Honor, I think that what is most important, turning to actually the comment in the previous case about meaningful notice, I think that what's important under 50A is meaningful notice. And to the extent that there's a debate—
Is what notice?
Is meaningful notice.
Meaningful.
So I think to the extent that there's a debate about whether there should be a categorical rule where you always need to name the person, I don't know that that's necessary to even reach that issue here. Because I could think of a notice of claim, like in the Fourth Department
Counsel,
case.
I'm sorry to
right?
interrupt you, but I'm
yes.
looking at the notice of claim,
Yeah.
paragraph 2.
Yes.
The very first claim is false arrest and imprisonment.
Yes, Your
A
Honor.
little redundant, but
And-
yeah,
and-
I mean, so that's some notice?
Your Honor, if the city is to read that notice of claim, and this is
So
there's going to be a long answer.
Concerns
But
the arrest.
bear with me.
You can reconstruct who the arresting officers were frequently. I mean, correct me if I'm wrong, from city records.
Your Honor, if you look at Mr. Wiggins' briefs to the Court of Appeals, right, false arrest can be against a prosecutor. And what he said to the Court of Appeals is he
Why
said—
are we talking about that? I thought we were talking about the notice of claim.
Your Honor, because there's nothing described as anything wrongful the police did, but they talk about the prosecutors violating his rights for 6 years, right? 6 years he's wrongfully incarcerated because the prosecutors had police officers who had multiple witnesses saying, Mr. Wiggins shot and killed this man. And we can certainly debate the extent to which police are doing too many things here, but I think that we probably all agree that if there's a fatal shooting, the police are supposed to arrest the person. And so there's nothing on the face of this notice of claim that would show that the false arrest is against the officers as opposed to against the prosecutors. And another way that we know that is Mr. Wiggins has sued his lawyers who wrote this notice of claim for malpractice. I can give you the SDNY docket number. And his lawyers in response Their defense, which I think is a viable one in a pending motion to dismiss, is he has no claim against the police here. That's what
How
the,
is that possibly binding on Mr. Wiggins, counsel?
I'm sorry, Your Honor?
How is that possibly binding on Mr. Wiggins?
It is, that is not, Your Honor, but what I'm trying to say is I'm trying to understand how reasonably somebody could read this notice of claim, read his filings to the Court of Appeals, which are certainly binding on him, Your Honor, and read the filings of the people who wrote this notice of claim who say that there's no claim against the police. And I think that a reasonable reading of that here, where it's 10 years of misconduct, and the point of the notice of claim is to give the city notice of the nature of the claim as against the police so that they can investigate. When they have 10 years of misconduct, I believe that under any department's approach.
So
affirmance
counsel, is
warranted
it
here.
your position that we don't need to even deal with the bigger issue, that we can simply affirm on the small issue of this particular notice of claim did not give notice to the police department that they should go back and start getting evidence with respect to the officers who arrested him for the murder, on the murder charge?
Or that they should do so, right? That there was a claim against the officers
Right.
here, right? That is right. So under the, especially because of stare decisis, I believe that's the prudent
Okay.
course for the court,
Okay.
course for this court to take here.
Well,
Counsel, I have
didn't
another
have
question.
anything to do with stare decisis. That's a whole different argument.
It's a way to affirm without even reaching the issue, Your Honor. Yes, that's exactly right.
Counsel, I have a question, because you also mentioned in your brief that the appellant could have also used a Jane Doe, John Doe designation. But please explain to me, how would that help you to investigate?
The reason that it makes a difference, Your Honor, is because the notice of claim requirement has to impart notice to the city of a claim as against the employees, right? And so in the Fourth Department case, for instance, which is about a single city employee driving a truck where debris falls off and hits the plaintiff, you could imagine a notice of claim where that, just by naming the city, it specifies a particular incident, which is very much unlike this claim. Even in Alvarez, the notice of claims at least said NYPD in it as a respondent, again, telegraphing to the city, potentially, an intent to file an action against the police. That's completely absent from the notice of claim here, especially when read against Mr. Wiggins' own statements to the Court of Appeals. The court may affirm on that basis without even reaching the question of stare decisis, Your Honor.
Thank you.
Thank you.
All right. Rebuttal?
The position of the city that this court does not need to reach the matter of stare decisis is wholly abhorrent. And further, I'd like to thank Your Honor for pointing out that the representations in the respondent's brief that there were admissions that my client committed the underlying criminal crime is also a gross material misrepresentation.
So let's just ask that then. What in the notice of claim gives the city of New York notice that you are seeking to hold the individuals who arrested him as opposed to anybody else? I mean, this is you're alleging a long period of misconduct.
So the issue,
Can you read it in the notice of claim? Where would one say, 10 years ago, better get the records of the arrest?
so in the notice of claim, which is page 66 in the record, there are causes of action, and those causes of action that are sought include the false arrest, false imprisonment, the assault, the negligent fulfillment of police duties. Most of those claims are attributable and can only be performed by an individual municipal actor. The city of New York cannot be accused of excessive force. That isn't.
No, but I'm saying to you, you've alleged excessive force by the corrections officers. What gives the city of New York, 90 days after the accident or the incident, notice that you think that the arresting officers used excessive force? That's what I'd like you to point out to me.
I respectfully disagree as to the conclusions that the notice of claim alleges excessive force against correction officers.
Oh, you haven't alleged that?
It does not.
Oh, you're not suing anybody in the corrections department?
No, Your Honor.
Oh, you're only suing for, I thought you were suing
The claims that were dismissed were purely against police officers, Your Honor, that were involved in
No,
the,
I'm talking about what you're suing for. Aren't you suing for maltreatment while you're in
no,
correction?
Your Honor, my client was caused to suffer injuries while incarcerated, but
Yeah.
those injuries are the natural sequelae of his false imprisonment, which was procured by the police officers who fabricated or also otherwise exaggerated evidence, Your Honor.
At the time of his arrest?
Correct.
Oh, okay, got it.
But if I may, otherwise, the notice of claim does contain a claim not only separate from the cause of action, looking for punitive damages. Punitive damages in and of themselves are damages that can only be sought against an individual which is a municipal agent. And further, to the extent that the false imprisonment, false arrest can be attributed to a prosecutor, whether it's a prosecutor or a police officer, the city would be required to indemnify either, and therefore they would be given the adequate notice that claims against an individual were forthcoming. And to the extent that there might be some discrepancy there as to their ability to investigate the matter, the investigation in a matter of a 16-year-old who is wrongfully imprisoned for 10 years should warrant such a plethora of investigation, and the sheer volume of documents and control of the city would easily avail itself to merely the identification of the names of the officers involved in the arrest. Any foresight would be, any arguments the opposite is just absent reality. And this is a matter where we're dismissing without even giving meritorious decision or the opportunity of the plaintiff to conduct discovery. This is not a summary judgment motion. This is a motion dismissed.
Yeah, we understand. Okay, thank you. Thank you both.
Thank you, Your Honors.
De Diaz versus Klausner, step up, please. You may proceed.
Good afternoon, Your Honors. May it please the Court, my name is Andrea Krugman. I'm here on behalf of Weiss and Rosenblum for the plaintiff appellant Evelyn Aguilera de Diaz. This is an appeal from the denial of a summary judgment motion on a pedestrian hit by a left-turning motor vehicle in a crosswalk. There's no appeal based on whether the lower court found that plaintiff met her burden of proof by establishing that she was in the crosswalk with the right-of-way, looked around before she crossed the street, and 1 to 2 seconds before she was struck by a vehicle, saw the vehicle out of the corner of her eye when it was too late for her to do anything about it. The lower court erred in holding that after the burden shifted to the defendant, that they actually met their burden by establishing a non-negligent explanation for the happening of the accident by saying she came out of nowhere and she must have jumped off the street, jumped off the curb into the traffic because otherwise he would have seen her. However, the statements that he made to the police report, which are corroborated by his own affidavit submitted in opposition to the summary judgment motion, actually say he never saw her. Anything prior to hitting her. Anything after that he surmises, he claims she did prior to the accident, is conclusory, yes.
Aren't there issues for, you're speaking about the denial of your motion for summary judgment on liability, right?
Yes.
Okay, so aren't there issues of fact to the extent that your client testified that she was walking east to west and the car was driving west to east and the damage was done on the west side of the car? Aren't there issues for a jury to determine?
No, I don't believe that there are, because one, defendant never established that those damages to the vehicle did not pre-exist. He's admitting, on the one hand, he's admitting she was in the crosswalk. After I felt the impact, I saw her in the crosswalk, and he hit her hard enough that there was damage to his car, but at the same time, said it couldn't have happened that way because she must have been coming from the other direction. But anything that he says about where she was coming from beforehand can't be taken as logical because he never saw her.
Well,
It's
counsel, though,
completely speculative.
isn't that consistent with where the damage was, that she came from the other direction?
Well, actually, I disagree, because if she's going straight and she's actually beyond where the front of his vehicle was, then he could have hit her from the driver's side, if that damage actually came from her, which he didn't present a biomechanical expert, he didn't present any accident
Well, all he has to
reconstruction.
do is create an issue of fact on summary judgment. Maybe you make good points for trial, but why isn't it sufficient for him? You can eyewitness with it which side of the car the damage is on. He's allowed to testify to that. Why isn't that sufficient along with his narrative account to at least create an issue of fact and have liability go to the jury?
Because he never saw her. So anything after that, he admitted that she was in the crosswalk. He admitted that he struck her. He admitted that she was had the right of way. And anything that he says where she came from, because it's all speculation. She came from the other direction. She came from nowhere. She came from the sky. She jumped off the curb. It's all speculation. And it's not supported by the fact that he said, I never saw her. So it's a full stop. He can't say
Can one
anything.
draw a reasonable inference from his testimony that he also said he was going extremely slowly? And so therefore the inference does support his statement that she came out of nowhere.
But it's not possible to come out of nowhere. You came out of somewhere. She
Well,
was
from
there,
running,
and
you know, I mean, he's using the term, you know, a phrase.
Right, to
we all
use it as a term of art. However, he didn't say that she wasn't there. He admits to striking her. He admits she was in the crosswalk. He
No,
admits
but the
that.
implication is that she inserted herself with some rapidity into the crosswalk or in front of his car, and that therefore he didn't have time to stop. Because he was going so slowly, you know, the fact that he didn't see her is sort of supports his statement, does it?
But if he doesn't see her, then he has failed he has failed to see what he is required to see.
Thank
And
you.
therefore, he's negligent as a matter of law.
Thank you. You'll have time on rebuttal. You may proceed.
Thank you, Your Honors. Good afternoon. May it please the court, my name is Stephen Castles. I'm with Bavaro, Cotter, and Bender. We represent the defendant respondent, Ronald Klausner. This was a motion brought on by the plaintiff before any depositions were held, at which point the evidence submitted in support of the motion was an affidavit and a police report only. In opposition, we submitted an affidavit as well, and this is an affidavit versus affidavit battle. And as a result, the words in those affidavits are all that we can rely upon. And here, and as you part,
Counsel, how could the assumption of risk defense, affirmative defense, apply here that you've asserted? You asserted an assumption of risk. What risk is it that you think she assumed?
So, thank you. So there were a number of affirmative defenses, one of them of which was the assumption of the risk, and it does relate and come down to her potential comparative negligence.
No, but you asserted comparative negligence. Assumption of risk is a different affirmative defense. Why did you assert that? I can't imagine what a risk you think she assumed, like as if she was at a football game.
Well, based on the facts known to us at the time, we did assert that as well as many others. But it all relates around the idea that at the early stage when we asserted our answer, we didn't know a lot about the actual facts other than what our client was telling us.
Not disagreeing that you have issues about comparative negligence, about her negligence, about a third party's negligence, but I don't see emergency doctrine. You asserted like literally every tort affirmative defense out there. And so the ones that I have problems with are emergency doctrine, assumption of risk. How do these apply?
I will concede that the assumption of the risk defense is not a viable one here. If asked of me, I would withdraw that, and it wasn't really briefed here today, but the emergency doctrine,
Well, it was ruled on below, right?
it was ruled on.
Right.
That's
Okay.
correct.
Thank you.
But I must insist that the affirmative defense of the emergency doctrine remain. And the reason why is that based on the conflicting testimony that was put forth by both parties, there is a genuine dispute as to whether, one, the defendant did anything negligent here, and two, the plaintiff's comparative negligence led to this accident.
You've already put in, we're good with comparative negligence. What emergency are you saying came up?
So, and that all relies upon the location of this accident. So the defendant's testimony is that he made a left turn into the first available travel lane, which is on First Avenue. Right to the left of that travel lane is a sidewalk island. Now it is the defendant's testimony that the plaintiff was on that sidewalk island, and our client, who was turning onto First Avenue, proceeded to travel through the crosswalk because there was no one in the crosswalk. Aside from the fact that the plaintiff jumped out from the sidewalk island into that left lane, this accident would not have occurred.
No, but what's the emergency? Where's the police car that cut you off? Or I'm not saying that you don't have a comparative negligence or even 100% negligence, but what emergency are you alleging occurred?
But the potential emergency that was presented to the defendant was potentially striking a pedestrian.
Oh, well,
So it was a sudden emergency, and that came without warning to him.
But I thought he didn't see her before he hit her.
Yes, that's his testimony.
So I thought the emergency doctrine was that you see something, but not in enough time to stop. But that's not really what happened here. He didn't see her at all.
Well, I believe the doctrine stands for the proposition that the defendant could have or should have anticipated the emergency. And here he could have, although he didn't actually see the plaintiff hop out the foot or so that it was into the side of his car.
So on your version of the emergency doctrine, wouldn't every car accident be subject to that doctrine? Isn't it aren't you taking a very broad look at it?
I don't believe so. I think it is. I think the emergency doctrine is based on a case-by-case basis. But I do want to point out that the defendant, based on his testimony, made it very clear that he did nothing wrong here.
Understood. Your time is up. We'll hear rebuttal from your adversary.
Thank you.
Thank you, Your Honors. Just very quickly, counsel just said that that defendant testified that the plaintiff was actually on the curb, but actually that was not the testimony. He never saw her beforehand. He only surmised that perhaps she was off just on the curb and jumped into the street. Aside from that, this case is indistinguishable from the cases that were very recently before this court, Maimon, and that was decided in June of 2021, case number 2020-04256, which was almost the exact same situation. Pedestrian had a crosswalk. She had the signal in her favor. She looked for oncoming traffic, and the defendants claim that plaintiff may have been in the crosswalk or may not have been in the crosswalk. He didn't know where she was. The fact that he admitted that he didn't see her until after the impact already occurred, which is the same exact situation as the one that happened with Ms. Aguilera de Diaz. So there is no distinguishing factor between the Maimon case and this case. The same applies on Curl versus Schiffman, which was decided.
In Maimon, there was an affidavit of an eyewitness, however, correct?
In Maimon, I believe there was an eyewitness, correct.
Doesn't that distinguish Maimon from this case where there is no eyewitness?
But the court didn't necessarily rely on the eyewitness. It relied on the plaintiff's. We're only talking about the shift of burden from the plaintiff to the defendant and whether the defendant met his burden to establish a non-negligent explanation for the happening of the accident, which here he did not. So there's no argument that the lower court found correctly that plaintiff did establish her entitlement to summary judgment as a matter of law. thereby shifting the burden. So the only thing that is up on appeal is whether the defendant came forth with a non-negligent explanation for the happening of the accident, which, having not seen her and admitting that he never saw her and admitting that she was in the crosswalk after the fact and stating so to the police, I think makes it clear that he has not been able to establish any negligence on her part, certainly not to allow his affirmative defenses. So you can't prove it based on anything that's submitted.
Thank you. Thank you both.
On limited damages issues, and I focus, it will become relevant in a moment, the limited nature of the motion, but the ruling implicates hotly disputed factual issues which were not appropriate based on the record on the motion. For quick efficiency, let me just touch in passing a procedural issue. As the trial court recognized, my clients, having invested $250,000, were entitled to two components in return. What's called the share award. Both parties at the time and through the litigation refer to the share award
Right.
for every.
Counsel, we're dealing with the date that the shares should have been transferred. At least that's an important issue here. The complaint, your complaint, says that the shares should have been issued contemporaneously with plaintiff's investments. Doesn't that mean the dates, August 22nd, November 29th, and November 13th?
Your Honor, we believe the trial court erred in two respects on that point in determining that the date of measurement should be the date of our investment when the shares should have been issued.
Isn't that what your complaint asks, though?
The complaint includes claims in equity. It includes claims for the value of the shares post the time of when the investment was made for two reasons. Factually, we were entitled to them. We were entitled to them on due demand at the time where we are collaborators with the company. We're working with the company. It's not issuing the shares. We're not adversarial. We're waiting. The company now, having waited, having delayed, cannot get the benefit of that delay. That's the factual issue, but there's a legal issue, separate, related, but separate.
But you're saying, counsel, that the dispositive date is the date when the plaintiff responded to the defendant's interrogatory, as opposed to the date when the shares were supposed to be issued?
That is correct, Your Honor. My only tweak...
Didn't you choose the date of to respond to the interrogatory?
We measured the value of the shares through the date of the interrogatory, through to the present time. We couldn't estimate the value of the shares after the date of the interrogatory. And the legal underpinning for that, we believe it's well established. It's consistent, indeed required by the Court of Appeals precedent, which the court and respondents rely on. The Simon versus Electrospace case. You measure the value of shares at the time they were supposedly to be delivered. When there's a liquid
the date of the
market,
breach, right.
when there's a liquid
Black
market
letter law.
for the shares. Simon itself says you measure it then because if the claimant wanted the shares then, she or he could go out and purchase those shares. Not only does the record in this case, the record before the trial court, rebut the liquidity of the market, or it's going to say not only does it leave the question unresolved.
Wait a second, there was an expert that put in information about that issue. Did you rebut that expert?
The expert, Your Honor, Your Honor,
first just ask me, did you put in anything to rebut what that expert said?
Your Honor, the answer is no, because the expert concedes the illiquidity of the market.
No, I don't, that's I don't think that's correct. So
If I
assuming
could
that I think that the expert said that you could buy and sell these shares, just assume that. Did you put in anything to raise an issue of fact on that issue?
Your Honor, we did not need to because that is not
I'm
what.
just asking you whether you did. Let's start with that.
Well, Your Honor, we did not because we can rely on that expert. If I could just finish the point, the expert's own
And when you
analysis.
finish the point, then you'll do the rest of your argument in rebuttal. Okay. So finish.
Just in a sentence, the expert's analysis shows you could not cover those shares for 1 day, 2 days, 5 days, 10 days.
Okay, thank
Thank
you.
you for the accommodation.
Your Honors, may it please the court, Gerald Bridges for the respondent. If I may introduce Russell Glazer of the Bar of the State of California and ask that he be permitted to argue the appeal.
You may. Thank you.
May it please the court, Russell Glazer on behalf of Lion Biotechnologies. Yes, the expert submitted a report saying that these shares were traded on the over-the-counter market, that there were 1.5 billion shares issued and outstanding available for purchase, that shares in multiple excess of the amount in controversy here actually traded hands in the general time period that we're talking about.
And counsel, did plaintiff put in an expert to dispute that expert opinion?
Plaintiff did not. In fact, Your Honor, plaintiff's argument on appeal, as I understand it, is they were entitled to specific performance because these shares were supposedly illiquid. The argument below was that the share prices should be determined by a jury. The complaint says nothing about specific performance. They said nothing below about specific performance. It's only when we get to appeal that they start talking about specific performance, and they don't rebut the fact that the expert said that these shares were obtainable. What they seem to be saying is because of the fact that shares in this quantity didn't happen to trade on that particular day, they couldn't have covered, but there's no evidence.
Assuming that we accept your expert's unrebutted view that you could trade those shares, then the breach, the damages are regular damages on the date of the breach. And the date of the breach, as alleged in the complaint, are those 3 dates. Is that your argument?
That's the argument on the issue, yes, and that's in keeping with the Simon decision, which has been the law of New York for 50 years and followed many times. As I understand it, the principal argument, or one of the arguments that counsel is going to address on rebuttal, is this notion that the trial court should not have held that there were no additional damages that could have been obtained by converting promissory notes into shares of stock in May of 2013. And I'd just like to point out, because it's not addressed in the plaintiff's papers, but below, they said to the trial court, if defendant complied with the terms of the agreement and the plaintiffs were able to convert the May 2013 financing, plaintiffs would have been due millions of total shares if not for the reverse split in 2013. So they made the argument below that we're entitled to millions of shares. By the way, they claim to have invested, as we say, as he said, $200 and some odd thousand. Millions of shares. And they're claiming that the trial court erred by responding to this issue. Now, we put in evidence, again through our expert, that they would not have obtained any additional economic benefit because they would have had to part with consideration equivalent in value to the shares that they would have obtained. Again, that's not rebutted. It's not even addressed in their papers below, and it's not addressed on the merits in their papers on this appeal. So, I mean, the only other argument, Your Honor, is, as I understand this point, that they want to construe their share grant as some kind of continuing option that would allow them to purchase shares up to the present time as though no split had occurred. The Simon decision addresses that as well. It says you're not entitled to convert a stock grant into a warrant or into an option. That's precisely what they're trying to do. The exercise is, what economic position would they have been in but for the breach? And that's what the trial court decided. And quite frankly, there was no evidence below or here to suggest that that was wrong. That's all I have, unless there are any questions.
Okay, thank you. Hey, Counselor, rebuttal.
Two brief points, Your Honors. First, going back to the expert, which we embrace on the issue of illiquidity. To use just one example, the expert focused on 3 days. One day, I believe, according to the expert herself, roughly 89,000 shares could have been retrieved by my clients. There was no shares traded that day, none. I think that bespeaks an illiquid market. At the very, very least, these
Counsel,
are...
how are you in a position to rebut the expert now when you didn't put an expert in to rebut that person?
The clarification I do want to convey to the court is we are not rebutting these numbers. The facts and figures from their own expert's mouth reflects an illiquid market, which then takes this case out of the paradigm.
No, but the expert opines, right? You don't like the opinion, but the expert opines on those numbers. You're an attorney. You don't have the ability to dispute an opinion of a financial expert. I mean, why would you, do you see what I'm saying? The thing is, you needed to put another financial expert in to say that opinion is incorrect, but you didn't.
Your Honor, I believe we are going to massively change basic procedure if there is now a requirement to put in a rebuttal expert when the other side's expert is not opining on
Counsel, it's
anything.
called shifting burden of proof.
Your Honor, and the burden of proof is on the respondent. In this case, it was the movement below, and it failed to meet that burden of proof. We believe that expert failed to assist it, in fact, makes our case.
So your position is that the expert on its face, incredible. I mean, I don't understand why the expert's opinion, you may not agree with it, but on its face, it would satisfy their burden, and you'd have to come forward to show that there was a disputed issue. And I think that that's really the issue that we're all trying to get you to focus in on and explain to us why you didn't have to do anything.
The data that the expert compiled reflects an illiquid market, which takes the...
How do we know that? Wouldn't you have to know about marketplaces and be an expert to try and figure that out? Is there some magic number? Oh, 89,000 shares traded. That's illiquid. I don't know.
I do know I'm at my limit, but if I could...
I'm the one who would stop you, and I haven't, so...
Thank you, Your Honor. I'm trying to be protective of the court's time.
No more than I.
The expert does not opine, nor could it, because it is a matter of law. It's a matter of law under Simon and progeny. The expert does not opine that this is a liquid market sufficient that you could get enough shares on that given day, nor would the expert have that expertise to opine on it. At the very least, there are disputed issues of fact here. In fact, the expert states that these were not freely tradable shares, quote unquote, not freely tradable shares.
Okay, thank you. Thank you both. The next case is Dimitro versus Dormitory Authority.
Good afternoon, Your Honors. Arnold D. Joseph for the plaintiffs, appellant, respondents. I'd like to use my time to focus, obviously, my appeal was
Mr.
based...
Joseph, first question is, I guess the verdict was rendered May 16th, 2018, and then we issued an order on an appeal On March 7th, 2019. Why were we not informed of the jury's verdict?
I have no idea at that point,
Were
Judge.
you on the previous appeal?
No, I was not on the previous appeal, and I was not the trial attorney.
You have no idea how that happened?
None.
Is that an acceptable answer in your view?
Well, since I wasn't retained, yeah, because for me personally, I understand exactly what the court is saying. But I am Johnny-come-lately after that occurred. Okay, there was no appeal filed by the plaintiff until after that decision came down, as far as my involvement.
All right, I don't want to take up all the time
No,
on that particular
Judge, I
topic.
didn't want to, right. I was going to leave the liability arguments to my learned adversaries, since my brief really focused on damages.
I actually, you know, since Judge Moulton brought it up, I think that your adversaries are going to have to answer that question as well.
I understand, Judge, and, you know, I'm going to fall on my sword. If I had been the attorney at the time, you would have been informed that this verdict had come down, but I was not the attorney at the time, okay? Let me move on now. I want to just focus the court's attention. You were supplied cases by the defendants to try and support their position that the pain and suffering awards for past pain and suffering and future pain and suffering were over the top and too much awarded by the jury. And that includes also the loss of consortium services action of the wife here. The plaintiff's position here is if you closely review the cases that you were supplied by the defendants, you will see that they actually support the numbers the jury supplied here. Or if they didn't support those numbers, they certainly support an increase from what the court below reduced them to. Decage. The plaintiff in my case is 39 years old at the time of the accident. He has 13 years of pain and suffering. I agree he only had one surgery during that time, but he has 3 times as much time as pain and suffering, plus he's a much younger man. And the court below, whether it looked at the amount of painkillers this guy took during the time he was injured, it's really scary.
So let's assume that we agree with the numbers that were awarded because they fell within a reasonable range or even below range. Let's assume that. How do we deal with the chaos that's been created, given the fact, how do we deal with the chaos that's been created, given the fact that the First Department was not informed of the fact that there was a verdict in this case? How do we deal with the chaos?
You know, Judge, listen, it affected my client eventually as well. You know, the only thing I think this court has to do is look at the record and the briefs that were before it on the issues of liability, look at your prior decision, and determine if, in fact, the case was made out against the defendant Cannon.
Well, so wasn't one theory of liability submitted to the jury that we ultimately dismissed?
That is correct.
So how, now what, I think is what we're all.
There were one other, just to buttress that question, when the jury got the issue about liability against Cannon, there was no distinguishing between the different theories that the plaintiff had raised. So we can never know what the jury based its liability on.
Your Honors, when it comes to Cannon, you're correct. I mean, I can't argue with you when you're right. So the problem that the plaintiff, me as the attorney has is I just wasn't involved at that level. However, be that as it may, the plaintiff's position here is, look, this is an apportionment trial at this point. It's a plaintiff's verdict. It doesn't matter, it matters to us, but it doesn't matter to us as much because we're going to go back and try the case and there's going to be an apportionment. And if it's any consolation to the court, this is probably would be what would happen anyway, even after review of the record, based on some of the findings with the other defendants, Metal Fab especially, coming to light where they were found negligent.
So from the plaintiff's point of view, just so we're clear what the interest here, your interest is making, or is maximizing the damages, because whichever way you slice it, it'll be apportioned up between whatever defendants remain standing.
That is correct, because there is no question, this is a plaintiff's verdict, and if that part is going ahead, if we go back for a new trial, which I hope that, cooler heads may prevail at some point, that won't happen, but at this point, we're gonna go back and retry the liability part, depending on what happens in this court on the damages. We could be retrying the whole case technically,
Understood.
but hopefully it doesn't go there.
Yeah, understood, just so we know what's.
Okay,
Mr. Joseph, I'd like you to address your argument with respect to the future lost earnings, and can you just explain why the jury was not entitled to follow the work-life expectancy that it was charged under the PJI? Can you address that?
Judge, the jury was certainly entitled to do that.
Yeah.
I would say, given, it's always the appellate attorney's problem that he's arguing with the jury on one part and against the jury on another. So I kind of left my point 2 of my brief alone, because I believe that my bigger problem in this case is not that.
Okay.
It's with the court below's reduction of the pain and suffering awards to the level that it did, and the loss of services claim.
All right, we'll hear from you on rebuttal. Okay. First defendant up.
I have to say, I'm a little taken aback by the court's inquiry, because I think, I've been doing appeals a long time, and I wasn't involved in the prior appeal, but I was involved in the trial and knew that the appeal had been decided. But I've had appeals before where stays weren't granted, the case had to be tried, and then the case went back later, and this court would dismiss a claim or make some other ruling after a trial.
No. First of all, the rules of the appellate division required counsel, all of you, to inform the court once the verdict came out. You're right, you don't get stays necessarily.
Right.
In this case, certainly because of the length of time and the number of people wasn't crying for a stay. On the other hand, once the verdict came out, the question became whether the summary judgment appeal became moot, not the issue, because the issue would have been subsumed within the judgment and all comes up for review. So yes, it would have made a big difference on some of the arguments that you're making today about the effect of this later summary judgment decision.
Well, Judge, I think I can understand what you're saying, and I'm not going to.
Counsel, who do you represent? Sorry, counsel, who do you represent, please?
I'm sorry, Christopher Small for Cannon. Sorry about that.
Yeah.
Thank you.
So looking at the rules, there obviously was no settlement, but as far as mootness goes, it's not really moot, because there were 2 claims against us, and this court dismissed one of them. We wanted a differentiated verdict.
The appeal was moot. The issue was still in the case.
Well, why was the appeal moot if on summary judgment?
Because we don't decide summary judgment when the case is finally determined. The issue comes up for consideration and review of the entire case. It brings everything up for review. You don't get to keep the summary judgment up on appeal.
Well, Judge, it wasn't an appeal from a final judgment. It was an appeal from a...
I can't believe you're
I
arguing.
understand
And I
that.
apologize. I mean, this is my
I can't
understanding.
believe you're arguing with
There
the
is-
rule, counsel.
Right, I
I'm
mean, there
sorry.
is a specific rule. You should have told us.
Okay.
All right?
I really, I mean...
And I think it's actually confusing a lot of the issues up here, because people are arguing law of the case. Could there be law of the case from a decision that really shouldn't have been rendered at the time? But on the other hand, was it a correct decision?
Well,
Was it a correct decision? I asked Mr. Joseph that too. What would be the effect here if, in fact, the issue of what theories of liability should have been presented to the jury, right?
Well, but this court said that one theory shouldn't have been, and the only result of that was a procedural issue in the trial court, because the court didn't differentiate. So on the Davis v. Colwell, you had to give a new trial. But
assuming for a minute that you didn't have the appellate division decision, assume for a minute you didn't have it, could you make this same argument? The answer is?
no, because...
Really?
No, but Judge, if you don't have the appellate division decision...
Of course you could make
have to talk about
could
both
make the
claims.
same argument that the proof didn't support the theory of negligent design of the breaching system.
No, but that's not our argument, Judge. That's not our argument here. Our argument here is focused on the negligent inspection claim. That's the only surviving claim. Nobody put any expert proof in
But
on
what
that.
did the jury hear?
The jury heard everything, but nothing
That's
on
right.
negligent inspection.
And what did the jury verdict sheet ask them to decide?
Just negligence.
Just negligence. So they heard two theories of negligence. How do we know
The judge,
which theory they found them
the
liable
judge,
on?
there was no expert proof as to negligent inspection. Nothing, from no party. So they couldn't have found anything. You need.
And nobody argued before the jury the negligent design of the breach system. Was that in closing arguments? I don't know how productive
I know
this
it's a little,
is, quite
it's a little quirky,
frankly.
but our position from the beginning apparently was the negligent design claim should have been dismissed, and this court agreed. So it never should have gone forward on that claim.
Okay.
It can be cleaned up.
You know
because-
what? No, not so easy, but
Well, I
okay.
think it can, Judge, because-
Honestly, you seem to have gone down, in my opinion, down a wormhole that wasn't necessary for your argument. I'll give you a minute to finish up, and then you'll have rebuttal.
All right, in very simple terms, this was a case where the negligent inspection claim required expert proof. Nobody submitted any expert proof. No party, not just the plaintiff, nobody. And I think the reason is clear is because there wasn't a negligent inspection here. The record's very clear that they detected these issues, told them for months in emails, you have to fix this. Nobody fixed it. And the person who makes my case for me is Dasney's representative. He testified at 1753 of the record. So when Chip Berry, he's from Cannon, told the dormitory authority and Bovis and everyone replace the cleanout covers, he did his job, correct? He answered yes. So we did the inspection correctly. That's why there was no expert testimony, because they couldn't find, there was nothing wrong with what we did. There was no issue.
Okay.
So that's our remaining claim here. Thank you.
Thank you. All right, next.
May it please the court, I am Jeffrey Ford, and I represent the respondents, appellants, Dormitory Authority, Bovis Lend-Lease, and Center Sheet Metal. And I'd like to say, as this bench has honed in on, the problem here is that we don't have a special verdict. We have a general verdict, and that's the problem with respect to my client's Center Sheet Metal. I submit that the court below erred in reversing the jury verdict in favor of Center Sheet on causation. Now, the interesting thing is, in vacating that verdict, the court below determined that the jury found that Center Sheet installed the angle iron that's at issue. We don't know that, because there's other theories that they could have found negligence on against Center Sheet. We don't know that they found negligence because of the installation of the angle iron, especially since the representative from Center Sheet, the vice president, Mr. Gainey, testified that they did not work on the particular port that's at issue. If we had a special verdict and the jury was given an interrogatory, then we would know. But the jury was only asked whether Center Sheet was negligent. Now,
Well, did your client propose a special verdict sheet?
I do not
no.
believe so.
Wow.
Okay, but I think.
I mean, if you don't propose a special verdict sheet, then aren't you precluded from coming up here and saying we don't know why the jury decided what they decided?
I respectfully disagree with that, because the justice who decided the post-trial motion was not the justice who tried the case. And the justice who decided the post-trial motion specifically stated and based her determination on the fact that she said that Center Sheet, the jury determined that Center Sheet installed the angle iron, and therefore there has to be causation. That would make causation inextricably intertwined with negligence, but that's not the case.
Okay, I think we understand your argument. Thank you.
Thank you.
Next.
Good afternoon, Your Honors. May it please the Court. Michelle Levin, on behalf of Martin Associates. The general law on liability between general contractors and subcontractors is quite settled, and under that law, Martin should be dismissed from the case completely. The law states that when a contractor employs an independent contractor for a particular task, it cannot be held liable for the subcontractor's work where the contractor does not control how the subcontractor performs its work. In this case, Martin was contracted to install the HVAC system, which consisted of a breaching component and a boiler component. It subcontracted the boiler components to ACS and Johnston Boilers, and it subcontracted the breaching to other contractors. Now, if those installations and the startup of the boiler were negligently done and that they caused the boiler system to vibrate, and in turn, the boiler system vibration caused the clean-out port covers to come off, then Martin can't be held responsible for that because all of that work—
Counsel, what is your solution for the chaos that's self-imposed here? I mean, are you asking that the whole case be retried?
I'm asking that Martin gets dismissed out of the case on account of the principles of negligence. We didn't create the defect because we didn't do any work that actually caused the system to vibrate. We also didn't, when the covers were coming off, we retained another subcontractor, CSM, to reinforce the covers, and CSM elected to reinforce the covers with angle irons, and we didn't control how CSM did it, nor were we actually on notice that the angle irons were defective. All of the emails that pertain to replacing the clean-out ports had to do with the fact that the clean-out ports, and this is where the attention to detail is really important, it had to do with the fact that the clean-out ports weren't providing access to clean out the actual breaching system. It wasn't a question of safety. Those emails never said that the angle irons were posing a danger, and the angle irons was ultimately came off and struck the plaintiff.
Okay, thank you. Next.
Good afternoon, Your Honors. May it please the Court, Jordan Palatiello on behalf of Analytical and Combustion Systems. As Your Honors correctly pointed out, there is chaos in this case. This matter was tried with jury selection starting on February 28th. Canon fully submitted their brief to this court on March 9th of 2018. A verdict was rendered on May 16th of 2018, and then Your Honors issued this court issued a decision on March 7th of 2019. The basis of this court's decision with respect to ACS, and I quote, "It's undisputed that the vibrations were resolved by a modification to the boiler system." That modification to the boiler system, we submit, was made by CSI 4 years after ACS left the project. That testimony was brought out at trial. It was objected to at the time as a subsequent remedial repair. It is our position that that evidence should not have been considered by this court in the underlying appeal, and it should not have been presented to the jury. The trial court, in its post-trial motions, relied not only on the CSI repairs 4 years after the accident, but also relied on this court's decision in the underlying appeal to say that the evidence, it was against the weight of the evidence to find that ACS was not negligent. Now, I submit to you, and Your Honor asked earlier, how can you know what the jury based its verdict on? I submit to you that both ACS and Johnston Boilers were the only defendants in this case in an over 2.5-month trial that defended the boilers, that said that the boilers were not the cause of the vibrations. It was the grossly undersized breaching system. The jury, by dismissing the case against both Johnston Boiler and ACS, found that it was the breaching system and not the boilers that caused this issue.
Now, that argument with respect to subsequent remedial measures, you didn't raise that below, correct?
The issue was not raised. Well, the issue was raised at trial that the testimony of Bill Lower and the testimony of CSI's repairs should not have been admitted, should not have gone to the jury. There was expert testimony from ACS's expert as well as Johnston Boiler's expert that
subsequent remedial repair simply derated the boilers and did not change what was happening. It was the derating of the boilers of 4 years later compensated for the undersized breaching system.
No, but wait a second. You made a post-trial motion. You didn't raise that issue in the post-trial motion, right?
I believe I respectfully, I believe that it was raised in the post-trial motions with respect to the subsequent remedial repairs by CSI.
Okay.
Thank you.
Thank you. Okay.
Good afternoon, Your Honors. May it please the court. Michael Kearns on behalf of Johnston Boiler. Johnston Boiler was not working on the construction project in the terms of the construction itself. What Johnston Boiler did was they had a purchase order with Martin Associates, who was the HVAC contractor responsible for installing the boilers. They sold 4 boilers to Martin, and Martin was responsible for the installation. The issues here on appeal as to Johnston Boiler is that the verdict in...
You were found not negligent.
That's correct, Your Honor. Johnston Boiler was found not negligent by the jury after, nearly a 2.5-month trial. And the evidence presented at trial was not against, would not warrant a reversal of the jury's decision. The jury's decision should stand and should not be overturned in any way based on ample evidence of what Johnston Boiler did at the site. They went to the site on November 30th of 2014 in response to Martin saying, can you check out this situation with the vibrations? They plugged some of the burners, and that was on November 30th of 2004. And then on December 1, 2004, they were also present. And then they said, this is not a burner issue on the boiler. It's the stack and the breaching system. And then Johnston Boiler sent their combustion engineer to the site on January 12th of 2005 to look at it. And he said, there's nothing wrong with the burners. Now you have then 9 months
CSM
lapsed.
was ultimately hired to reinforce the covers, correct?
Correct, Your Honor. But Johnston Boiler had nothing to do with reinforcing the covers. That was center sheet metal. And so you had 10 months lapse between when Johnston Boiler leaves the site in January of 2005 and the accident occurring on October of 2005. And they were never called back, and there was ample evidence, as indicated in our brief, that why Johnston Boiler was not negligent, and the jury could reasonably infer from that evidence that Johnston Boiler was not negligent, and we submit that the verdict should stand.
Thank you. All right, rebuttal?
I didn't want to get roped into this liability argument, but apparently I don't have much of a choice. I think when you look at this case, in my brief, I put too many cooks spoiled the broth. I think this is a prime example of that. I think the defendants are all pointing fingers at each other. And if you go through this record, almost every one of them at some point had something to say about what the problem was. And if a jury was sitting there, we talked about the jury in this case, listening to all this, I think at the end of the day, they looked at the 3 people that were in charge of the majority of the work here, and that was Cannon, Martin, and Bovis. And Bovis was the construction manager, Cannon designed the system, and Martin was the contractor for Bovis to put it in, and that's who they ended up finding responsible, along with I think Metal Fab, who had manufactured the actual angle line itself, and claims they didn't install it, but that may not be very credible. At the end of the day, I apologize to the court. I wish I had been involved.
Counsel, just let me ask you this one question. Do you agree with counsel for Martin that there was no evidence that other than hiring the subcontractor?
That Martin's claim here that they have no involvement in this case, it's not credible. You can't make that claim. They're everywhere.
Was
Their
there
footprints
testimony?
are all fingerprints, footprints. There's no question why they got held 50% at fault. And this idea that because they're the contractor, that they're not responsible and they subbed out the work, they had their own people there doing this. It's just not, there's a reason they were held in 50%. It wasn't magic.
Well, that's why I asked you, because counsel
Yes.
argued that all they did was sign a contract and give all the work to someone else.
and
So
I think-
my question to you is, in your view, there was plenty of evidence.
Absolutely, and I addressed this in my brief, and, you know, they're going to get rebuttal, and I again apologize to the court. I wish things had been different.
I think we all agree, right? Okay, all right. Go ahead, 1 minute rebuttal.
Thank you.
All right.
You know, you're probably not happy to see me again, but I take my reputation very seriously. So I just wanted to come up again and say, you know, I apologize if there was some misunderstanding with the rules, but our position has always been there never should have been a design claim in this case. This court vindicated that on appeal. And if there's any mootness here, I don't view the verdict as mooting this court. I view this court as mooting that claim. So that leaves one claim that this court said was still an issue of fact. And on that, nobody presented any expert testimony. So at the end of the day, our position is the same, is that Canon did nothing wrong here. It inspected it properly. It alerted them to these issues. We didn't install the angle iron. Nobody told us about the angle iron. We didn't approve that. And when we detected the other issues with they put the wrong piece on. They were supposed to use the port, and they used a T. We told them that's not the proper output. That's not the right thing. Change it. Five times over the course of 6 months, including once before this accident. We said, did you get this done? You need to fix this. Nobody did. At the end of the day, Dasney's witness said it the best. We did our job. Thank you.
Thank you.
In response to Martin's argument, I think there's sufficient evidence in the record that Martin did have responsibility to make sure the breathing system complied with all specifications. There's also evidence in the record concerning a delay between Martin retaining the contractors to reinforce the breaching system. Thank you.
Okay, thank you. Next.
May it please the court, on behalf of Martin Associates, just in reply to ACS and Johnston Boilers, regardless of whether ACS preserved the subsequent remedial measures argument for appellate review, the evidence of CSI's repairs were in fact properly admitted. They went directly to the condition of the boilers at the time of the plaintiff's accident, and also went to who had control over these boilers, who was capable of making the adjustments that would have prevented the vibrations from happening. And to the extent that Johnston Boilers was also capable of making those adjustments and did make adjustments, they just didn't make enough adjustments.
Counsel?
Yes.
May I just interrupt you and ask you, do you agree with Canon that if except for the evidence on the struck out theory of liability, there was no other evidence of liability on Canon, on Canon's part with the liability theory that we didn't strike out?
Actually, I don't agree with Canon's position on that. There was evidence that went into Canon's responsibility in performing inspections and also in approving shop drawings. So some of the things that were claimed to be improper were the clean-out ports, for example. And Canon had those shop drawings, which did not designate where exactly the clean-out ports were or the size of the clean-out ports.
So you're saying there was evidence on both theories of liability, not just the one that was struck out by us later?
Correct. Okay. There was evidence that went in on the theory that they were negligent with respect to their approval of shop drawings.
Okay.
Thank you.
Thank you. One more.
Thank you. On behalf of ACS, I'd just like to reiterate that ACS was most affected by the failure to notify this court of the jury trial, because this court issued its decision with respect to the theory of liability with respect to the breaching system versus the boilers. And if this court was notified, the court could have taken all of these appeals.
There was nothing stopping you.
Judge, we were not a party to the underlying appeal.
Ah, the other appeal.
We were a party to the lawsuit. We were not a party to the underlying appeal, did not appear, did not submit any briefs. As such, the trial court, in rendering its post-trial decision relied on this court's decision of the appeal that happened after the trial. Just with
But why wouldn't we have the same decision even if they didn't rely on it?
Judge, there was
The facts in the record didn't change.
there was ample evidence that was presented at trial with respect to the breaching system being undersized as compared to the boilers causing the vibrations, which the jury ultimately found. And the jury found that even with hearing of the subsequent modifications from CSI. And how do we know that? We know that because the jury found that both ACS and Johnston boilers, the only two parties responsible for the boilers, were found to be not negligent.
Okay, thank you.
Thank you.
All right, thank you all. It's been interesting.
Such a polite.
Okay, Lorne versus 50 Madison. Okay, Counselor, you may proceed.
Thank you. Good afternoon, and may it please the court. My name is Janisa Urbano with the law firm of Clark Golden Attorneys at Law. We represent the appellants who are the underlying defendants, 50 Madison Avenue LLC and Sampson Management LLC. Admittedly, the briefing is extensive in this case, and we rely heavily on our submissions, but today I'd like to focus on the legal question in front of this court, and that is, should the respondent's common law fraud claim be dismissed because it is duplicative of the breach of contract claim? And this court has found many, many times that when the two claims mirror each other, the fraud claim must be dismissed.
Counsel, wasn't this argued in a previous motion?
Your Honor, I submit that while it was brought up in the previous motion, it was not, Justice Heitler at the trial court level did not address it. Rather than look at the two claims and make a comparison of whether the fraud claim was in fact mirroring the breach of contract claim, in the trial court opinion, the justice merely distinguished the two cases upon which we relied heavily, which was Alexander and Guttrell.
She said you had a procedural impediment to raising it by another summary judgment motion. Isn't that, I know you wanted to deal with the substantive, but we have a gateway issue here, don't we?
With all due respect, Your Honor, I don't believe so. The two procedural arguments that were brought up by respondents are the law of the case and successive summary judgment motions. Both doctrines, I submit that this court has the discretion to ignore completely should you decide to do so.
Law of the case, we're not bound by a trial court's law of the case, that we know, all right? But successive summary judgment motions is a rule actually that we honor because there's an efficiency to making parties bring only one summary judgment motion in a case unless there are exceptional circumstances. So why do you fall within the exceptions?
So this case falls within the exception. The original summary judgment motions were brought, well, it's a 14-year-old case, so it's hard to say early.
We are aware.
But they were brought before discovery was closed. This summary judgment motion was brought after two additional depositions were taken, a deposition of Stephen Tolley, who's a third-party witness.
But why would that, I'm sorry, and then why would that affect the argument about duplication? I mean, isn't that an argument? You don't need discovery to say that fraud is duplicative of a breach of contract claim here.
No,
that's a preliminary motion that you can make because you look at the causes of action, you look at the relief, you look at the facts underlying them, and you see what the allegations of duty are.
Yes, Your Honor, and that's what we're asking this court to do because we believe that the trial court.
So you have to get to my question, which is why couldn't you? Why would the passage of time have affected that? Why shouldn't that have been either decided or, if you didn't like the decision, appealed in the first summary judgment?
Well, Your Honor, in the first summary judgment, again, we don't believe it was addressed as part of the decision. This appeal is from the the second, the summary judgment motion
Wait a
that did
second,
bring
you're
up the
saying,
fraud,
counsel,
duplicate evidence, and
let me
this is the
interrupt you
appeal.
just a second, because I literally just read Judge Emily Jane Goodman's decision last night. You're saying she didn't address the substance of fraud versus breach of contract in the first summary judgment decision? Because I saw page after page on that issue.
We assert, Your Honor, that Justice Goodman looked at the claims in terms of the issues of fact and not the legal question. That's the
She
distinction
made a
that was made here.
decision on summary judgment, which you chose to make at your peril before discovery, and she upheld on summary judgment, not pre-answer dismiss, summary judgment, the fraud claim on the substance, on that, and you made that for that exact same issue before her, correct?
You're correct in that it was.
You
That was
argued the same exact thing before her that you argued in front of Judge Heitler 10 years later.
I don't believe they mirror each other completely, no, Your Honor, but,
Okay, but the
Justice Goodman did
substance
uphold.
was, it's duplicative, correct? You argued that in front of Judge Goodman, Emily Jane Goodman, and the same thing in front of Judge Heitler.
The argument in front of Justice Heitler was indeed that the fraud claim was duplicative of the breach of contract claim.
And that's what you
correct.
argued in front of Judge Emily Jane Goodman.
Yes.
All right, and you never appealed that denial.
That decision was not appealed.
Okay. Justice Gish, may I?
You may.
Counsel, what was the newly discovered evidence that even entitled you to make the successive summary judgment motion?
So there was a part of the motion in front of Justice Heitler also included a consumer fraud claim, which was dismissed, that goes to one of the depositions, which was the deposition of the real estate professional that worked for the sponsor defendant. And the second piece was the piece that goes to the dismissal of the fraud claim for, which dovetails both between the duplicative argument and the no issue of fact argument, which is the deposition testimony of Mr. Stephen Tolley, who is a third-party witness that gave extensive testimony with regard to the condition of the concrete floors and whether or not they were suitable to accept the hardwood flooring that was specified for this unit, which is one of the major defects of which the respondents complain.
So what does that have to do with duplication?
So the respondents, as I understand part of the respondents' argument, is that it's not duplicative. They're saying it's not duplicative because there were misrepresentations made pre-closing about whether or not the concrete was suitable to accept the hardwood flooring, and that because of an architect report, which we submit is not suitable evidence, but the respondents do, that architect's report showed that Sampson and Madison, the appellants here, somehow knew pre-closing that the concrete was defective. And obviously, we disagree with that statement.
Okay, thank you.
Good afternoon, and may it please the court. Stephen Orell, Schwartz, Sladkis, Reich, Greenberg, Atlas for plaintiffs' respondents, Simon and Ludmilla Lorne. And I'm going to lead off with
Let's leave the procedural aspect of this aside. I am interested in your argument on duplication because I'll be honest, at first blush, these seem duplicative to me.
Our point, and the point Judge Goodman and Justice Heitler accepted, is that we allege, and you have to compare this to all the other offering plan cases. I know, Justice Scarpullo, you had one of them that's cited here, dealing with omissions in offering plans, dealing with representations as to things which were in progress, which would be built and delivered someday in the future. It's not this case. The representation we're relying on for the fraud claim, and it's pretty narrow, relates to the statements that were made to the Lornes pre-closing, even after signing the contract. It was signed in, I think, January, and closing was in September of 2005, that this apartment would be move-in ready, would be habitable. The one thing Mrs. Lorne testified to was that
Wasn't that part of the duty under the contract to deliver a habitable premises or premises that had a C of O? I mean, weren't there representations made about, weren't there obligations in the contract of sale regarding the condition of the premises that would be delivered at closing?
I don't know if it's in the contract of sale, but generally with respect to new condominium sales, you can't start selling until the building has a certificate of occupancy. So yes, there's a certificate of occupancy. We know, I think the court knows, that in many, many of these cases, units are not in fact habitable, notwithstanding that there might be often a temporary certificate of occupancy, which sometimes can be renewed over and over
Wasn't there
again.
an obligation, and I know you're talking about the offering plan, but the offering plan gives the parameters about what the contract of sale is. Usually the contract of sale is in there. Aren't we talking about the obligation under the contract to deliver a habitable premises?
The specific fraud claim is not the contract claim. It's that the apartment would be move-in ready. Not just with respect to punch lists. There was a sprinkler leak, which actually prevented them from moving in for a time. But the fraud claim here relates to one thing, which is the concrete substrate, which we alleged made them have to repair the floors over and over again. It's actually...
That's not a breach of, that doesn't come under the breach of contract?
It is a breach of contract to not deliver what was promised in the offering plan.
What was promised?
What was promised was, there are plans laid out in the offering plan, there are specifications. Those were promised, but the specific promises that were made to Ms. Lauren at the closing, before the closing, you can move right in after the closing. We don't need to fix anything. Everything's going to be ready. Well, I overstated slightly. They're the punch list items, but it'll all be done quickly. There was nothing stated to her that, oh, we're going to have to rip up the floors multiple times, bring in architects and engineers and do measurements, and years later, you still won't be able to live in that apartment because there's no floors there. So she was told, you'll be able to move in on the date of closing, and it didn't happen. That's the fraud claim. It's a misrepresentation of existing fact.
I don't understand that. I don't get that. It's a misrepresentation that I intend to perform under the contract. That's exactly what you're saying. That's all you're saying. What else is it that you're saying? There's no other fact except your obligation to perform that duty under the contract. That's a straight up breach of K. I still don't see what outside misrepresentation you're talking about.
Because they knew when they made that representation orally to the Forbes that the floors were uneven because the concrete was defective.
They knew they couldn't perform the contract, and they didn't, right?
No, making a promise.
That's exactly what you're saying. I still don't get it.
Well, making a promise and knowing you cannot perform can be fraud. Collateral to the basic.
It's not that's. I mean, it might be a lie, but it's not collateral to the contract. That's my only point.
Well, it's collateral if you induce somebody and you say that this is ready, this is good right now. Not it will be, but it is. It's move-in ready on the date of the closing, and you know it's not. That's what we say happened here.
Okay, thank you. We'll hear from your adversary in rebuttal.
Thank you, Your Honor.
Thank you.
With regard to any knowledge of the concrete substrate at pre-closing, there's not a scintilla of evidence that the appellant defendants had any knowledge about the concrete. First off, the appellate defendants state that the concrete actually is fine the way it is and can receive a hardwood floor. But notwithstanding the fact, the pre-closing representations made was that the unit would be move-in ready. Yes, there were some defects, and those defects would be corrected within the time period prescribed in the contract. The respondents say, I moved in, I didn't like it, there were a lot of defects, and you didn't fix them in time. That is a breach of the promises that are held in the sales contract and the offering plan, and that's
So,
all it is,
counsel,
not a separate duty.
May I just interrupt you for 1 second, please? So that means regardless of whether or not we dismiss the fraud claim, this case isn't done. You're going on the breach of contract.
That's correct, Your Honor. We do not believe that we have a position to ask for summary judgment on the breach of contract claim at this moment.
And this case is 14 years old?
This is a 2007 docket number in the underlying case.
And the status of the underlying case, are you coming to trial anytime soon?
Finally, there has been a notice of issue issued by the plaintiffs. And at this point, we were waiting for this appeal. We'll ask for a status conference with the trial judge and set a trial date when we know what we're trying.
Okay, thank you.
Thank you, Your Honors.
Thank you both. And the next case is People versus Francis. Step up, please. You may proceed.
Good afternoon, and may it please the court. Megan Byrne for Appellate Gordon Francis. Mr. Francis's case is one of the rare cases where a several-year delay in bringing him to trial violated his constitutional right to a speedy trial. I know Your Honors have heard a lot about Mr. Wiggins today, and I will actually be referencing the case as well many times in regard to his criminal appeal, because this case is a lot like the Court of Appeals case. Yes?
Do we have minutes here? But can we review the 3030 claim?
Well, Your Honor, this is a constitutional speedy trial claim, so unlike the 3030 claim, it doesn't necessarily need to be broken down in the same way, although there are many minutes, and there certainly are minutes establishing what it is that we're arguing here. Namely, things that I think that aren't even in dispute, such as the fact that there was a new DA put on this case years into it that caused them to have to kind of rethink the whole case, caused a lot of delay, and that there was a mistrial caused because the prosecution declined to discuss evidence that it had for 2 years. And then on the eve of trial, when half the jury was already picked, the prosecution said, oh, there's this piece of evidence we'd like to put in, and that caused a mistrial, which again delayed the case. And so I don't think we need, all of the adjourned dates to go over that.
Well, the trial court, in deciding the speedy trial motion, applied the Tanovich factors. Some weighed in your client's favor, some not. What was wrong with that? What did she do that was wrong?
And she weighed the correct factors, but weighed 2 of them incorrectly.
Which ones and why?
So as far as of course, this here we're talking about a delay very like that in Wiggins. Here it's over 5.5 years that Mr. Francis sat in prison, or in jail, sorry, before his trial ever happened.
Didn't some of that have to do with the DNA testing that the defendant agreed to? Defense counsel agreed that it would be perhaps exculpatory?
To be clear, and if you look at the minutes, the defense counsel is saying repeatedly, and I can quote, "We are continually frustrated by the fact that Mr. Francis has been in jail at that time over 4 years on a case that is somewhat marginal." And so he does go on to agree to the testing because he believes that it will help to and to exculpate Mr. Francis. But I think it's important to note that defense counsel wasn't even aware that this testing, which is of a hair found at the scene.
Slow down.
Sure.
What did you say?
Of a hair that was found at the scene in the 90s. Defense counsel wasn't even aware that it existed. So years into prosecuting Mr. Francis, when he's already sat in prison for years, the prosecutor's like, oh, in addition to that, we would like to test this hair. Eventually, defense counsel says, we're sick of delay, but we believe it's going to help exculpate Mr. Francis, so of course we're going to consent if that's what you're going to do. And before that, the mistrial had been because the prosecution had a recording of Mr. Francis from 2012, and then 2 years later, on the eve of trial, said, oh, we have this recording from 2012 and we want to introduce it. So these are very clearly avoidable things. And I just want to be clear that, unlike 3030 with a constitutional speedy trial motion, it includes things that are not just the fault of the prosecution. Really, it doesn't have to all be at the fault of the prosecution. We're not saying they're acting in bad faith. We are saying that this also encompasses, the delays of the system, congestion in the court, and we believe the prosecution made the incorrect choice in deciding not to disclose these things earlier, not to do the testing earlier, particularly where Mr. Francis had been connected to this case 3 years before he was even arrested. They had his DNA and had already connected him. So the fact that it then took another 5.5 years to bring him to trial just seems to be, undue delay. And certainly under Taranovich, the fact that he was sitting in jail for all those years weighs heavily in terms of looking at these factors in scrutiny, and also weighs heavily in terms of prejudice. which is the other thing I would address. Of course, in Wiggins and in this case, prejudice is presumptive. If you're in jail for 5.5 years before you go to trial, there's just presumptive prejudice there that we really can't specify exactly what it was because we don't know. But there are a couple of things that I could point to specifically that did happen in this case, such as the fact that the prosecution got an informant, I guess, that was in jail with Mr. Wiggins after he'd already been in jail 4 years on the case. And allegedly they spoke to him. And so they're literally gathering evidence as Mr. as Mr. Francis is sitting in jail. Same as the phone calls of the recording of him being in jail. That's evidence obviously gotten while he was incarcerated. So essentially they're kind of building up their case, albeit slowly, while Mr. Francis is sitting in jail and he is being prejudiced.
Thank you.
Good afternoon, Your Honors. Rebecca Hausner on behalf of the people. Dismissal of the indictment is not the appropriate remedy in this murder prosecution where the evidence at trial compellingly and overwhelmingly proved that the defendant stabbed a man 25 times in 1993. The trial court below on the speedy trial motion correctly weighed the Taranovich factors. I'd like to just respond to a few of the comments counsel has made now in argument. With respect to the good cause analysis, and despite the fact that this is not a 30-30 case, this is a constitutional speedy trial case, the absence of minutes does still matter here, and it matters because it makes the good cause analysis quite difficult when we don't know precisely what reasons were at issue for some of the delay in this case. But what we do know is that any delay that can be attributed to the DNA evidence, so that's roughly the 15 months that's at issue when we're talking about the DNA analysis of the hair strand that was recovered when the new prosecutor was brought onto the case. All of that was deemed by defense counsel below to be potentially exonerating. And as Your Honor pointed out, it was something that the defense pushed for and was eager to do, that DNA analysis.
Counsel, if I may, I want to
yes.
stick with the hair
Yes.
testing because I know that there were some delays. OCME could not do it. Then there was a private company, but they were backed up, and then they went out of business without finishing it. And I know that the people gave updates. Now, isn't it correct that after you gave the updates, the court invited the parties to go forward for trial, and defense counsel declined that request?
Absolutely, Your Honor. Thank you for raising that point, and I would direct Your Honor's attention specifically to the January 23rd, 2017 minutes, where the court essentially said, if you want to proceed, defense, then all you need to do is say that, and basically we're going to expedite this. And there were several adjournments after that. We don't have the minutes, but even subsequent to those adjournments, defense counsel on the record maintained his position that it was his position from the get-go that that hair strand should have been tested because it was potentially exonerating. So that it truly just underscores the fact that this is not a situation where the defense is merely being dragged along or acquiescing to the delay. They are affirmatively creating part of the delay because they insisted that the DNA testing go forward. Turning just briefly to the prejudice prong, I just would like to point out that presumptive prejudice alone cannot carry a Sixth Amendment claim. And turning first to the fact that there was no specific prejudice in this case, I realize counsel now says on appeal that there was specific prejudice associated with the confession that occurred while defendant was incarcerated to another person who was incarcerated. That was not pointed to in the motion papers below. That is an unpreserved argument. There was no specific impairment alleged such that the speedy trial court below considered that in assessing the Taranovich factors. And I would also further like to point out that even after the Court of Appeals came down with the Wiggins decision, this court has continued to weigh the absence of specific prejudice, even in cases where there's been a lengthy period of pretrial incarceration. And that is the appropriate analysis here, where there is no specific impairment that can be proven to the defense. And so much of the delay was attributable to the defense in this case. So unless your honors have any further questions, we'll rest on the brief.
Thank you. Rebuttal?
Thank you, Your Honors. So to be clear here, when we're discussing the, for instance, the mistrial caused by the prosecution's belated discussion of a phone call, that caused a delay of about a year, and I don't believe that we need the minutes to discuss that. And Wiggins is also clear that, so in Wiggins, the two primary reasons for delay was that there were requests for adjournments that were consented to by the defense, and the prosecution was trying to advance its own theory of the case. It's very similar to here. Here, the two main causes of this delay was DNA testing, some of which surely, yes, Mr. Francis did agree to because, again, he believed that it would help his case. And to be clear, the DNA testing, it all pointed to other people. It pointed to someone else under the fingernails of the decedent. It pointed to someone else leaving their DNA in the anus of the decedent. It pointed to fingerprints on an alcohol bottle that was not Mr. Francis's. So it did do that, but I think it's very an important distinction here is that Mr. Francis didn't know about a lot of these pieces of evidence until the prosecution would slowly unroll them as time went on over a period of 5.5 years, which I think makes that a bit different. And as in Wiggins, this is a murder case, that was a murder case. And as in Wiggins, there was, as I said here, a lot of evidence that made the prejudice all the more prejudicial, where there are a lot of pieces of evidence pointing to someone else as having committed this murder, having been around the decedent. And then regarding the prejudice, again, we don't have to point out prejudice, but I don't know that this court has had cases like this so often where it's over 5.5 years of delay, and where the prosecution themselves has belatedly disclosed evidence multiple times in the same case that has caused delay.
Thank you. Thank you both. CIT Group versus Star Surplus.
Good afternoon. May it please the court. My name is Chris Carlson, and I represent the appellant insurers in this appeal. The key issue in this appeal is whether or not CIT, the insured, submitted evidence to establish that it owned the aircraft at the time of the alleged loss. Now, the policy at issue provides coverage only for aircraft in which CIT had a financial interest at the time of the loss, and the loss occurs during the policy period. So CIT, as the insured, had the burden of establishing the existence of all the conditions of coverage. One of those is that it had the financial interest in the aircraft. And for purposes of this case, that means ownership. And there's been a lot of back and forth in the briefs about what the proof submitted meant, but that's really besides the point. They had the affirmative burden of establishing they own the aircraft, and they failed to do so. And for that
Counsel,
reason—
are you saying that they should have had the April 30th, 2013 order from FRS in the record? It was their responsibility to provide that?
Yes, Your Honor, under the context of this case, because what we put— so they had the burden, and we could have been silent on the issue of ownership. In fact, I think that we proved there was no ownership by CIT, and it was the Federal Revenue Service.
But that's the order you're relying on to say that there was no ownership. That was a confiscation of the plane.
The proof that we submitted was the decision by the Sao Paulo court that was issued in September of 2014, wherein the court reversed the repossession proceedings when they found out what happened. Actually, the CIT did not own the aircraft. Now, that decision was provided to us by CIT in discovery. They did not object to its admission into the record. They did not object to the accuracy of the translation that we provided, and they never, even up until today, they have never disputed the correctness of the statement by that Sao Paulo court that the issuance of the confiscation order affected a transfer of title. And that would have happened back in 2013.
Right, the date of that order was September 3rd, right? Because I think the trial court refers to it as September 23rd.
Well, what happened, judges, there was the order which said we're going to reverse what we did.
Right.
And then I think 2 weeks later, the decision, which is connected to that order, is where they discuss the reasoning. And where that quote says that the issuance of the confiscation order affected a transfer of title. I would note that that decision also quoted from a different decision from a different Brazilian court, the one where CIT itself tried to challenge the confiscation. And that court said that CIT did not have standing to challenge that confiscation because it didn't own the aircraft. And its only remedy was a claim for damages against Savan.
So, counsel, did anyone put in that FRS confiscation order into the record?
Your Honor, we asked for it, we never got it.
So how do we know whether what you're saying is correct? How do we know confiscation under Brazilian law could mean a bazillion different things? How is it that we should accept you, New York lawyers' representation that this confiscation order meant that they didn't own the aircraft?
No, Judge, it's not my representation. We're relying on what the Sao Paulo court said. The issuance of the confiscation order effected a transfer of title to the Federal Revenue Service. That's a statement of Brazilian law made by a Brazilian court in a decision given to us by CIT. And up until today, they've never challenged it.
Well, didn't that court also say that it would be premature to terminate plaintiff's repossession proceeding, the other proceeding that was going on that the plaintiff brought for repossession? Didn't it say that as well in the same decision?
I'm sorry, did it say what as well, Judge?
I'm sorry, it's hard with these masks. Didn't that court also say it would be premature to terminate plaintiff's repossession proceeding in that same decision?
Yeah, they did, Judge, as a matter of judicial efficiency. But
Well, I mean, that's your interpretation of it, right? But we don't have the order, so how do we know?
because they said that in the decision by the Sao Paulo court. There's a specific affirmative statement of Brazilian law. Now, again, I need to back up. Even if that was not proof that they did not own the aircraft, that's not my burden. We, from the get-go in this case, in our opening briefs and our opposition briefs, took the position that they did not own the aircraft at the time of the loss because of the confiscation order. That put an affirmative burden on them to establish that they did, in fact, own it. And they simply did not do that. They could argue all they want with our evidence, but they did not put in any affirmative evidence. Now, all they did was crawl with our evidence. But as I said, up until today, they've never challenged the correctness of that statement of Brazilian law. I would add, I'm running out of time, if this court were to accept that, and there was a lot of talk in the briefs about the effect of the Brasilia court's August 8, 2014 order, which effectively let Savan use the aircraft during the pendence of the appeal, or that litigation. But if this court accepts our proof and our position that the Sao Paulo court's decision establishes that they did not own the aircraft, then we submit that the coverage has to be barred under the known loss doctrine. Because if the confiscation order affected a transfer of title in April of 2013, that means that the loss of the aircraft as a result of a confiscation by the government took place.
Wait a second. Didn't they suspend that order?
I'm sorry?
Wasn't that order suspended?
No, well, but I'm getting to that, Judge.
So
we don't.
It may or may not have been. Right?
No, but Judge, we don't agree that it suspended it. But just follow the timeline. You have, if you accept that the confiscation order transferred title, that means CIT lost the aircraft as a result of a confiscation by the government. The policy under which they sought coverage incepted on April 1 of 2014. That was about 11 months later. So on the day that the policy incepted, CIT was seeking coverage for loss caused by confiscation of a government.
When did the Brazilian court suspend the FRS order?
I'm sorry, Judge?
When did the Brazilian court suspend the FRS order?
When did they decide it?
Suspend
we don't know. It was sometime.
Assume that it was, you may not agree, but when does your adversary allege it was suspended?
Oh, but Judge, my point is the suspension.
Okay, but let me back up. Just when did that occur?
I'm having trouble hearing you, Judge.
I know,
Ask me when was actually a
when
decision.
When did the Brazilian state court suspend that FRS order?
Assuming they suspended it, it was on August 8 of 2014.
So that's during the 2014 policy period that you're disputing right now, correct?
Well, yes, Judge, but the point that I was trying to make is if CIT lost ownership in April of 2013, they did not have ownership on the day the policy incepted. The Brasilia court's order suspending the confiscation order wasn't issued till 4 months after the policy came into effect. And there's no basis for them to claim that if it was barred by the known loss doctrine on day one of the policy, because they were seeking coverage for a loss, the exact loss that already occurred, there's no way that 4 months later, when the Brasilia court suspends that confiscation order.
Aren't they fighting that? They're fighting that order. It's not like, right? They're fighting that order. They don't accept that they've lost the plane by that point. And in fact, they fought it and won because it was suspended, correct?
Our argument stands on the fact that with respect to the confiscation order, that it affected a transfer of title.
At that time, in 2013, even though there was a subsequent suspension of that order that essentially put them in the same place that they were.
But Your Honor, respectfully, you can't look at that suspension in isolation because the known loss doctrine is effective on the date, if the loss has already occurred and is known, on the date the policy incepts, there is no coverage.
Okay, but they get the plane back at some point, right? So they get the plane back so there's quite a question whether the loss occurred in 2013, 2014, or 2014, correct?
They succeeded.
They get the plane. There's no doubt they have the plane at some point, correct?
Yeah, I agree with you, Judge. They went in and they made an ex parte application and lied to the court and said we're the owners when they were not.
Maybe they did. Maybe they didn't. We're just doing a motion right here, right? So, okay. Thank you.
Thank you.
Thank you.
May it please the court, on behalf of CIT Group Equipment Financing, Robin Michelson from Blank Rome, introducing Omid Safa of the bars of Maryland and DC, who's been admitted pro hoc vice. May he proceed?
You may.
Good afternoon. May it please the court. My name is Omid Safa, representing respondent CIT Group Equipment Financing. Notwithstanding the amount of ink that's been spilled in the briefing, this is ultimately a very simple insurance case. The result is dictated by the language of the insurance that the appellant sold and the governing law, which is New York law. It's not Brazilian law. It's not Brazilian importation law. Now, the record shows that CIT was in the equipment financing and leasing business, and it purchased insurance from the appellants to cover its entire fleet of aircraft that fly all over the world, including the aircraft that was eventually lost in Brazil. Now, CIT purchased not only the standard all risks coverage, but also coverage extension for war and allied perils. That extension expressly ensures CIT's interests in against the physical loss of the aircraft when caused by an enumerated peril.
Right. You admit that there's no coverage in 2013-14 policy year and then the 2015-16 policy year, correct?
Yes, Your Honor, because there was no loss in 2013. And there was no, and the loss had already occurred by the time of the 2015-16 policy year. The loss occurred during the 2014-15 policy year.
Say we agree with you. Is there an open question as to whether the government of registry exclusion applied?
No, Your Honor, there's not an open question.
Is an insurance certificate enough to prove that?
Yes, Your Honor, the insurance certificates, one, we introduced the insurance certificates and corroborating testimony from CIT's head of corporate insurance, who was also the corporate designee and had the knowledge of the company in preparation for a deposition. So both of those were submitted, but the certificates themselves are actually endorsements, and they, notwithstanding the objections from the appellants, they are contractual documents with independent legal significance, and they are not, therefore are not hearsay. And if you look at the documents, they certify not only that whole risk coverage has been provided, but that also whole war coverage has been provided. And then when you turn to the next page, it indicates that under the hull and war coverage, that CIT would be paid for a total loss of the aircraft. There's no evidence in the record that to contradict the certificates and the testimony of Ms. Lasagna. The insurers simply offer these objections, and one of them was an authentication objection.
I'm going to ask you what perhaps is a real easy question. In your view, did CIT own the possession during own the plane during the period in question? Your adversary says yes, and you say?
I believe the adversary says that we didn't own the plane.
I'm sorry, got it backwards.
Right, sorry. So yes, we did own the plane. CIT did own the plane, and part of the confusion here is that the insurers are relying on documents that aren't in the record and that are interpreting Brazilian law. Here we're dealing with New York law and an aircraft that was leased to a lessee, where the lease is governed by New York law, the lease amendment is governed by New York law, everything is New York law. And the insurers, they don't offer anything in their briefing with respect to CIT's rights under New York law. In fact, the only—
So, counsel, let me ask you this as a corollary. When do you think the loss occurred?
The loss occurred in 2014. September 23rd was the last day that CIT had the aircraft. And as a result of the Sao Paulo court order, which did not reverse, it did not say that we didn't own the aircraft and we reversed. It suspended its own repossession order in deference to the ongoing litigation between FRS and Savon. But as a result, Savon was able to use that order, come back and take the aircraft out of CIT's hangar, and then CIT was never able to get the aircraft back after that.
In your view, is there a distinction between possessing the plane and owning the plane?
In this case, no, Your Honor, because one of the things I was going to point out is the only case they cite under New York law with respect to ownership or title actually supports CIT's argument here. They cite the Bacalar case, 619 F. 3rd 136, for the proposition that a thief cannot transfer good title. Where here, the underlying administrative proceedings had nothing to do with CIT. It was the lessee who was accused of wrongdoing, alleged importation violations, and the confiscation order was entered as a sanction against the lessee's alleged wrongdoing. The lessee's wrongdoing can't strip CIT of its rights, and certainly can't strip it of its ownership rights. And that decision is also important in another respect. It highlights that you can't assume that the laws of two different jurisdictions are the same on the issue of ownership. In that case, there was a drawing at issue that had been stolen by the Nazis, had been seized by the Nazis, and had, through subsequent purchases, had made its way into the hands of a bona fide purchaser who purchased in good faith. And there was ultimately a dispute, and at the trial level, the trial court sided with the bona fide purchaser, saying, well, Swiss law applies, and Swiss law will allow this with respect to a bona fide purchaser. The Second Circuit vacated and remanded and said, no, New York law applies here, and New York doesn't allow thief to be title to be passed through a thief. In sum, New York is very protective when it comes to another party wanting to come in and take your stuff.
All right, thank you. All right, rebuttal?
Thank you. Just three brief points. Counsel's statement that the confiscation order and the proceedings had nothing to do with CIT simply is not true. The confiscation order was issued against the aircraft. That's what they were confiscating. And the Sao Paulo court decision talking about it was talking about transfer of the asset to the Federal Reserve Service. So they weren't a stranger to this proceeding. They didn't bring it about, but it was their aircraft that was being taken. Number two, counsel's statement that we did own the aircraft, that it just doesn't get us there. They had the affirmative duty to prove a financial interest in the aircraft, which in this case meant ownership. There was not a title put into evidence. There was not deposition testimony from someone with knowledge. There was not an affidavit. There was not anything. All they did was dispute the evidence that we put in. And even if they are correct and they successfully disputed what we said the evidence showed, that still leaves a vacuum. And that does not entitle them to coverage. They have an affirmative duty to establish, by admissible proof, all of the conditions to coverage, one of which was ownership. Finally, with respect to the issue of the exclusion and the exception to the policy, there was, again, they had the burden of proof. We had the burden of proof to establish the application of the exception, which we did, or the exclusion, which we did. They then had the affirmative duty to come back and establish the exception. They did not. What they did is they put in, attached to an attorney's affidavit, an email from an unidentified person in Brazil, which said, here's the certificate. Then as a separate exhibit was a copy of the certificate with no authentication, and it was incomplete, it was undated. And then they offered the testimony of their insurance manager who said, yes, Yvonne did get the policy. She didn't have the certificate in front of her.
Isn't that enough to at least get a hearing on whether there was a policy in place at the time sufficient to come within the exception?
I'm sorry, Judge, I can't hear you.
I'm sorry. Isn't that enough to at least require a hearing on whether there was an actual policy in effect? Assuming that our general rule applies, that a C of I doesn't prove coverage, but it is some indicia that there is coverage, shouldn't there be a hearing to see if an actual policy exists?
Well, I don't think, Judge, because they had the burden of doing on the motion. I mean, we can't go back and revisit this. I also would point out—
Why not? We revisit things all the time, or we direct hearings all the time.
Well, the other thing that I would point out, Judge, is you say there's indicia because they had Savon's name on it and all the rest of it.
No, because of the COI. Honestly, that is, a general rule that we follow, that the COI doesn't necessarily show coverage, but it's some indicia, and it doesn't prove coverage, but it's some indicia, and it's enough to at least get you to the point where we have a hearing.
Judge, on its face, because they put it in, I'm sure they're going to say it's indicia. My point is they had a burden of doing that by legally competent, admissible, authenticated evidence, and they didn't do it, and they had the opportunity to do it. But I will also add, sort of contrary to that indicia of that they had it, was the internal CIT email traffic that's in the record, in which, and I know this doesn't prove that there was no coverage, but the CIT people themselves were saying, you know what, Savon changed insurers to Fairfax, and this investigation's been going on for 5 years, and they never told Fairfax about it. I assume they're going to have a problem with that. And I think, again, it's not proof of anything, but it's just as much indicia the other way that Fairfax rescinded their policy because Savan misrepresented that the aircraft was not confiscated when in fact it was. And I'd also point out that
So counsel, doesn't that just mean no summary judgment? These were motions for summary judgment, right? And so let's go to trial, as Justice Gish just said. Let's go to trial on this issue as to whether or not there was even that second thing you had to do, that second part of the insurance requirement. It doesn't mean you lose. It means there's an issue of fact. There's some evidence one way, some evidence another way, right?
it's not evidence, Your Honor, because it's not admissible. It's really no more at this point than counsel's argument.
Okay, all right, thanks.
Thank you.
Thank you.
Thank you both. Romero versus Valdez. You can proceed.
Thank you. Good afternoon, Your Honors. Brett Nomberg, Brand, Nomberg, and Rosenbaum for the plaintiff appellant. This is a hit in the rear of a stopped vehicle establishing prima facie entitlement to summary judgment. So the only issue is whether or not the defendant presented evidence to defeat that. And they did not, Your Honor. All you have to do is look at the police report and the defendant's affidavit, and it's clear as day, Your Honor. The police report on page 85 of the record says, operator of vehicle 2 stated he did not see vehicle 1 before the accident. Now let's go to the defendant's affidavit. Did they meet their burden? First, it starts with Luis Javier Valdez being duly sworn, deposes, and says. That's the exact same jurat that the plaintiff used that defense counsel complained was not proper. Going to paragraph 4 is pretty much their entire defense. I'll read the portions and highlight the ending of it, of paragraph 4, which is very significant, Your Honors. Prior to the accident, I was traveling westbound on the Cross Bronx Expressway in the leftmost lane of 3 lanes for moving traffic. I was traveling approximately 45 to 50 miles per hour behind a Jeep SUV when it suddenly and abruptly changed lanes. Once the Jeep changed lanes, I observed a vehicle approximately 80 feet ahead. This vehicle was stopped in the leftmost moving lane of traffic, and here's the key. There was no traffic ahead of it, and traffic conditions around that area were light. What does the term it and that refer to in that sentence in plain English? It refers to the plaintiff's vehicle. I don't care if there's traffic ahead of the plaintiff's vehicle. We know that there's no traffic ahead of the plaintiff's vehicle because it's stopped and disabled in the left lane. After everybody goes past the plaintiff's vehicle is when the traffic ends. This was a carefully tailored affidavit that talks about what happens after, not before. So if he would have said, no traffic ahead of me, that would have been different, but it doesn't state that. So when the court in its decision stated, and I'll quote it, there was no traffic ahead and traffic conditions around were lit, meaning light. Which traffic conditions? The traffic conditions ahead of the plaintiff's disabled vehicle? They're meaningless.
Also, I'm sorry, what follows from this?
I'm sorry?
I don't really understand where this is going.
So,
we know he was the one who hit the plaintiff's vehicle. So there wasn't any car between him and the plaintiff's vehicle. Were you trying to say that after the white SUV got out of the way, that he had enough time to stop? Is that what you're saying?
No, Your Honor, I'm sorry, I'm not clear. The defendant has a burden to show that he was not negligent, that he was aware of the traffic conditions. And the only traffic conditions, instead of saying when they're driving in the left lane, what are the traffic conditions in the middle lane and in the right lane? Because my client says all traffic, and obviously it has to happen. If there's a disabled vehicle, nobody's passing in the left lane, everybody's going around. He does not comment upon what the traffic conditions were in the middle or the right lane. All he talks about is the traffic conditions ahead of the plaintiff's disabled vehicle, which is irrelevant. That's one of the issues that they have to show, that they were keeping a proper lookout. But it's more than that, Your Honor. So if you look at the affidavit, there's no mention at all about the police report admission. It doesn't even mention it, completely ignores it. So he doesn't deny exactly what he's told the police. He doesn't say that, I didn't state that. He doesn't deny the accuracy. So that admission stands without any denial of it. There's no mention of the distance that he was of the SUV behind it. So if you're traveling behind a car, you want to show a non-negligent explanation, you have to show you're not tailgating the person ahead of you, because obviously if you're tailgating him at 50 miles an hour, of course you're not going to be able to stop in time. So he fails to state what distance he was from the vehicle ahead. So for all we know, this guy was one car length or even less of the SUV. He also fails to state the speed of the SUV. If the SUV is going 25 miles an hour and he's approaching him at 50 miles an hour, well, that would be negligence for not slowing down. He doesn't address that. He also doesn't address the speed of any of the other vehicles on the roadway. So we have no idea whether traffic is actually slowing down. He also fails to state whether the specific vehicle ahead of him actually slowed down, had his brake lights on, and put his signal on beforehand so he would have reason to know and expect that there was a car in the left lane.
Mr. Nomberg, I'm going to ask you to finish up your argument since you're already over your time.
I'll reserve the rest for my
Fair enough. Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Ari Rubel from Carmen, Callahan, and Ingham, and I represent respondents Valdez and Copper Services. On the night of accident, Valdez was traveling in the leftmost lane of the Cross Bronx Expressway westbound. He was traveling approximately 45 to 50 miles per hour.
We pretty much know those facts, counsel, but what the plaintiff is saying is that there's not enough detail in Mr. Valdez's affidavit, and other variables that are not accounted for that might show an absence of negligence on Mr. Valdez's part, such as how fast was he going? Well, we know how fast he was going. How fast was the white SUV going? How close was he to the white SUV? He does say categorically in the police report that he didn't see the car at all before he hit it, and he does say something slightly different in his affidavit about that. So can you address those issues?
Right, that's correct, Your Honor. There are questions of fact, many questions of fact in this case. Appellant's counsel has brought up several of them. All of these details that weren't included in the affidavit, partially the lack of detail is due to the fact that no depositions have yet taken place in this case, and not every detail.
Well, regardless of whether there was a deposition, your client knows what he did and what he saw.
Right.
So the detail that's lacking is from your client's account, so that discovery doesn't change that for you.
Your Honor, that's correct. Although, despite these alleged missing details, the primary thing here is that there was the primary facts that were included in the affidavit were that there was a Jeep SUV traveling in the lane ahead of him, which obscured his view of the lane ahead, suddenly and abruptly changed lanes, revealing plaintiff's completely disabled vehicle in the lane ahead without its hazard lights on. And this accident occurred at nighttime. So that question, the question of facts that were presented by the affidavit are sufficient enough by themselves.
Didn't he also say something about not being able to get into the middle lane?
Correct, Your Honor. He did testify that he took action immediately upon seeing plaintiff's vehicle ahead. He was unable to change lanes. However, he applied strong pressure to his brakes in an attempt to avoid the accident. However, he was unable to do so. And as to the appellant's claims regarding traffic conditions, it's our contention that Valdez's affirmations actually state that the traffic conditions were light in the general area, not that they were light just ahead of plaintiff's own, or appellant's own vehicle.
And we do note that the vehicle in front of your client's vehicle did not make contact with the stopped car, right?
That's correct. They did switch suddenly and abruptly out of the lane ahead. The First Department has consistently held in such cases with similar fact patterns that's enough to create an issue of fact, and based upon the emergency doctrine, to warrant denial of summary judgment. That includes in the more recent Richards case that was decided by this court, and in Gonzalez and Markowitz as well. Similar fact patterns requiring denial of summary judgment based on issues of fact. There's also the question in this case scenario as to plaintiff's own comparative negligence. I know that appellant had argued Rodriguez that he's not required to provide or defend his lack of negligence in this case. However, he was asking in the summary judgment motion for dismissal of the affirmative defenses of comparative negligence and emergency doctrine. So he is required to actually prove his lack of negligence in this case. He was in a disabled vehicle in the leftmost lane of the Cross Bronx Expressway. Could he have exited the highway? Could he have not entered the highway in the first place if he knew of mechanical operational difficulties with the vehicle? Had he kept an eye on his gauges, especially the temperature of his engine, to see if the vehicle was overheating, and preemptively exited the highway? Did he remain on the highway too long a period of time instead of calling someone to come and tow the vehicle or calling the police to come assist? Was he correct in exiting his vehicle in an attempt to fix the engine or fix the vehicle instead of staying in his vehicle? There's all these questions of fact, and plaintiff has not responded to any of them, as to his own client's negligence in this case. And as to the alleged inconsistency in the statements, may I finish?
You can finish your point.
Alleged inconsistency. We agree Valdez's statement in the police accident report is true, albeit incomplete. In his affidavit, he completes what he meant to in the police report in stating that he was unable to see plaintiff's vehicle until the Jeep SUV suddenly and abruptly changed lanes, revealing plaintiff's disabled vehicle without its hazard lights ahead.
Thank you.
Thank you, Your Honors.
Hey, rebuttal?
Your Honors, when you compare two statements, the first statement is the police report. It doesn't make a difference what the defendant said he meant to say. You're comparing what his affidavit says, and you're comparing what the police report says. I did see the vehicle. I did not see the vehicle. That's the definition of inconsistency, because both statements cannot be true. And once you find that, then everything in the affidavit as a matter of law is a feigned issue of fact and goes out the window, Your Honors. As to the affirmative defenses, Your Honor, there's a police report, if you accept that the defendant never saw the plaintiff's vehicle before the accident. If he never saw the plaintiff's vehicle before the accident, then he can't dispute the plaintiff's assertion that his hazard lights were on. If you go by his affidavit, he says that he saw the SUV, he saw the plaintiff's vehicle as soon as the SUV...
Wait a second, counsel. Couldn't it be that he didn't see your vehicle because there weren't any hazard lights on?
Not on a
Isn't that
well-lit roadway.
exactly what he's saying? That here's why I didn't see the plaintiff's vehicle, because the plaintiff didn't put any hazard lights on.
If you go by the affidavit, Your Honor,
Yeah?
his affidavit says as soon as the SUV changed lanes, he saw a plaintiff stop vehicle and braked hard, right?
Right.
So if that's true,
Right.
what he says, then it makes no difference whether the hazard lights are on. The only purpose of the hazard lights is to see a stopped vehicle. He says he saw the stopped vehicle as soon as the SUV changed lanes. So it has no relevance.
I don't agree with that. I think that you can see, if someone has hazards on, you can see them over vehicles. I mean,
Particularly at
that's your-
nighttime.
Yeah.
I agree with
The
Judge
fact that,
Scarpullo.
that I don't come to the same conclusion as you do.
Could we agree that the purpose of the hazard lights is to see the vehicle?
What I'm agreeing with you is that there is a dispute over whether or not your clients actually had hazard lights in.
Well, I think if you say you saw something, then it doesn't make a difference whether you had warning about it because you already saw it, Your Honor. He admits he saw the vehicle as soon as the SUV changed lanes. So what would the hazard lights have added to anything at that point?
Okay,
Thank you.
Thank you. Thank you both. Ladder Capital versus Portfolio Hotels. Okay, you can proceed.
Good afternoon, Your Honors. May it please the court. My name is Brad Gardner of Polsinelli. I represent the appellants here, 1250 North SD LLC and San Diego Hotel Circle LLC. This is a fairly straightforward appeal that involves the interpretation of an arbitration provision. The key question here is going to be what the phrase "the subject of" means and whether or not a management agreement is inherently the subject of dispute over a subordination agreement when the only subject of that subordination agreement is the management agreement itself. I think the answer to that question has to be yes under the facts here. This is a case that initially stems from a $5.75 million mezzanine loan that went into default, and Ladder Capital, one of the other plaintiffs here, initiated a foreclosure on the collateral for that loan, which were membership interests in two LLCs, the plaintiff, or the appellant LLCs here, that own the San Diego DoubleTree Hotel. After that, or prior to the foreclosure sale, the respondent here, Portfolio Hotels, was the manager of the hotel. After the foreclosure, Portfolio's role as the manager was terminated, and the Ladder's affiliate that owns the hotel now installed its own management company. In connection with the loan, when Portfolio was managing the hotel, it was an affiliate of the then ownership group, and there was a management agreement that was in place that governed Portfolio's running of the hotel. As part of the loan, a subordination agreement was entered into among Ladder, Portfolio, and the loan borrowers that effectively said that any of the fees that were due and owing to Portfolio under the management agreement would be subordinated to the debt that was owed to the lender, Ladder. After the foreclosure, a substantial deficiency remained. Shortly after the foreclosure, Portfolio made a demand for some unpaid management fees that its affiliate had failed to pay it prior to the foreclosure. Due to some procedural deficiencies, Ladder, or the hotel owners, rejected those arbitration demands. Once Ladder discovered that Portfolio was attempting to collect these fees in violation of the subordination agreement because Ladder hadn't been paid in full, Ladder initiated the underlying litigation in the Supreme Court, seeking a declaratory judgment that all of the fees due and owing under the management agreement were in fact subordinate to Ladder's remaining debt. Once Ladder decided to initiate that lawsuit, the hotel owners elected to join their claims against.
So what section of the management agreement would anyone have to interpret to find out whether or not the debt was subordinate?
That's a good question, Your Honor. I'm not sure that that one would need to get very far into the weeds of the management agreement.
No, I don't see any. I mean, all you have to do is look at whether or not it's subordinate. All they're seeking is to say, someone gets paid first before someone else, having nothing to do with anything in the management agreement. It's just who gets paid first, right? That's the breach of contract claim.
Effectively, our position is that they're just simply inextricably intertwined. The two documents, the subordination agreement wouldn't exist.
What does it matter? How are they into? You're saying I don't owe you any money under the management agreement, right?
The appellants have.
So how is that intertwined with who gets paid first?
Again, our position is the fact that the subordination agreement that Ladder sued under in count 1 of the complaint wouldn't exist if it weren't for the management.
I'm just asking you, how are those two issues intertwined? Whether or not I get paid before you do, how does that intertwined with I don't owe any money under the agreement?
Well, so there's two separate pieces there. One is the whether or not the two are related in the fact, they're related in the fact that everything here relates back to the management fees. Whether or not they're owed, the hotel owners may dispute who gets paid
I'm
first is
asking
what
you,
matters.
you just said the two issues are inextricably intertwined, and therefore, even if there are two separate agreements, we should keep them together. And
Yes.
I'm asking you, how are they inextricably intertwined?
Our position is because if it weren't for the existence of the management agreement, the subordination agreement that we're fighting over separately simply wouldn't exist. The only subject of the
Wait,
subordination agreement
the management agreement was first, right?
by a couple of days. It was all done in connection with the same underlying
exist. It doesn't, whether or not you signed later on, signed a subordination agreement, that agreement existed before the subordination agreement.
It was all part of the same underlying transaction.
Okay.
Thank you.
Right, thank you.
May it please the court?
Counsel, I have a question for you.
Yes.
So your adversary says that the two agreements are inextricably intertwined. In your view, would a dispute under the management agreement have to be resolved first in arbitration, and then if there's an issue, it would be resolved pursuant to the subordination agreement?
No, Your Honor. The question here is whether the subject of the lender's claim in Supreme Court is the subordination agreement or the management agreement. To answer that question, all you have to decide to understand is which agreement do you have to read to decide the lender's claim about construing the subordination agreement. The question answers itself. It's the subordination agreement. The management agreement could be reduced to a judgment before you even think about subordination. And it could be just a bill, X owes Y, Z dollars. That's typically how a subordination question that's posed by the declaratory judgment claim comes up. Someone gets a judgment, a lender has a superior claim, and after all questions under the management agreement are resolved by a judgment, resolved to a number, then you start dickering over who gets paid first. So you don't have to know this notion of intertwinement. You don't have to know anything. That management agreement could be a black box, nothing but a number on a page. And you could proceed to decide the subordination agreement. That's what Justice Maisley understood. Was she said during oral argument, hey, I have to decide which of these two agreements, these two distinct agreements, is the subject of this third-party claim that you want to glom onto. Well, obviously, it's the one I got to read. She said, the subject of my lawsuit, the lender's claim, is this subordination agreement. So I don't have any jurisdiction here. There's an arbitration clause because this exception to arbitration doesn't apply. That's basically the beginning and end of this whole discussion. If there's any question about whether this exception applies, Justice Maisley didn't even get to the other issues we raised. Just even if this exception applied to the arbitration agreement, allowing you to proceed with a lawsuit, she said, well, gee, even if it was arbitrable, the management agreement says exclusive venue is in California. So what are you doing here? So it would be out anyway. She stopped there, basically, at oral argument, and didn't even get to the fact that, hey, If you tried to litigate in New York against Portfolio, the owners tried to litigate in New York against Portfolio on these claims, you haven't established personal jurisdiction. You haven't established subject matter jurisdiction. This whole dispute under the management agreement, the owners.
You made that personal jurisdiction argument in front of Judge Maisley, but she didn't reach it, correct?
Didn't have to. She didn't reach it. It was made. It's briefed. The subject matter jurisdiction argument is briefed, and she decided the venue issue. Essentially, basically, she said, "Look, even if I didn't have this arbitration problem, you got this venue problem." 2 was enough to knock it out. She didn't reach 3 and 4. She figured, you didn't get past first base. Why worry about whether you're going to be able to steal bases? So that's basically it. I think the rest of it's in the brief, unless there are more questions. Thank you.
Thank you. You have 2 minutes in rebuttal.
Just a few brief points. The one I would like to point out with respect to my argument that the subordination agreement and the management agreement are inextricably intertwined, the management agreement is an exhibit to the subordination agreement as part of considering the subordination agreement and whether or not there's any fees that could be subordinated. I think the court would have to at least look at and consider the management agreement to understand what we're asking to be subordinated. I think one key question, and it's raised in our brief, is whether or not the subject means the only subject. Our position is that common sense and a reading of the agreement is that it doesn't have to be, it just has to be a subject of the subordination claim. And I think the way these agreements are connected, it's at the very least a subject of the subordination declaratory judgment claim. With respect to the points that Mr. Burns covered at the end about subject matter jurisdiction and personal jurisdiction and venue, I don't necessarily agree that that Justice Maisley got there. I'm not sure I agree she got beyond the arbitration provision in her decision. To the extent that she did, our position, as we laid out in the brief, is that the very broad consent to joinder contained in Section 14.1 of the management agreement doesn't limit the third-party action or the hotel owner's ability to join to a third-party action to a suit that's brought in any particular jurisdiction or venue. It simply says if there's a third-party action that fits within that definition as it's set forth in the arbitration provision, that any claims against the portfolio or vice versa against the hotel owners can be joined to that action. So that would mean, it's an extremely broad consent and would include a joinder here. It doesn't say only if that action fits within the choice of venue clause that happens to be contained in the management agreement. So we believe that covers that particular issue. If there's no more questions, that's all I have. Thank you, Your Honors.
Thank you. The next case is People versus Shakur.
Good afternoon, Your Honors. May it please the court. My name is Michaela Pickus from Aiken Gump, representing Jaleel Shakur. First, the gun in this case was the product of an illegal seizure and should thus be suppressed. When officers ran into Mr. Shakur, it was nearly an hour from the original shooting, which occurred several blocks away, and officers did not have a description of a potential suspect. Mr. Shakur's illegal stop.
He was walking with 2 people that the officers recognized, however, from near the scene of the shooting. Is that correct?
He was walking with 2 people from a group of 20 to 30 people that officers had stopped prior to stopping Mr. Shakur. Also in that group of 20 to 30 people were 2 people that the officers stopped and searched due to a bulge in their waistband, and they only found a cell phone and keys.
This was still an active investigation, right, of a shooting in which the gun hadn't been recovered.
That's correct. There was a shooting, the gun hadn't been recovered. When officers found Mr. Shakur, they mistook him for someone in the larger group of the 20 to 30 people that he stopped, and they said to Mr. Shakur, "Didn't I tell you all to disperse?" Mr. Shakur complied with the officers' directives and ran away. Then the police chased him and stopped him.
Did they say stop police before that, however?
Before that, they said, they did not say stop police. They said, didn't I tell you all to disperse? Mr. Shakur dispersed, and then they said stop.
Well, he ran away, right? He started running. I mean, that was his method of dispersing?
Yeah, which was
Okay.
in compliance with the police directive.
But did the police then give him a different directive? Did they say stop, police?
After he began to run, they did say stop.
And he didn't stop?
He did not.
Okay. Did the police testify that when they had observed them, they observed a bulge which they believed might be a gun?
The police testified that they saw a bulge in Mr. Shakur's waistband, but a bulge alone is not enough to establish reasonable suspicion.
But is it a reason for inquiry? Can you get to a level 2 on that?
Your Honor, it may or may not be, but they did not inquire. They did not stop Mr. Shakur and ask him questions. They conducted a level 3 seizure, which...
Well, when they say stop police, is that a precursor to, you know, we're coming over to ask you questions, maybe?
It could be, but they didn't. They seized him, they arrested him.
And they couldn't inquire, he went running.
He did, in compliance with the police directive.
All right, was that enough when he started running to convert what might be a level 2 to level 3 to reasonable suspicion?
No, Your Honor, because...
Why not? Tell me.
Because all they had was a bulge in his waistband and compliance with the police directive. But they said disperse, he dispersed. Whether or not he did so enthusiastically, whether or not he ran, he was still complying with the police directive. And none of this provided reasonable suspicion to justify Mr. Shakur's stop. Moreover, the timing was intended...
Wasn't it more than just a bulge in his waistband? Wasn't he fussing with it?
He was fidgeting with the bulge. Moving to the second point, Mr. Shakur's confession. Mr. Shakur's confession should have been suppressed as involuntary. Mr. Shakur was 19 years old, sleep deprived, sick and nauseous, and returning from the hospital. He was locked in an 80-degree room. On top of Mr. Shakur's illness and lack of sleep, detectives used coercive tactics to get their confession. Detectives exploited Mr. Shakur's physical illness, ignoring his hospital gown.
So did you raise the issue of illness below?
I'm sorry, could you repeat that?
Did you raise the question of his being tired and ill below? Is that preserved?
I don't think they did raise it below, but we're arguing as a due process now. So detectives exploited Mr. Shakur's physical illness. They ignored his hospital
The illness,
gown.
though, that was asthma that he had been admitted the previous night?
That's correct. He had asthma the previous night. He was in the hospital.
But the question then arises, because as you know, he asked for a cigarette and he smoked it. So how much pulmonary distress could he have been in? Doesn't that undercut the statement that his illness was a cause of or part of the background of coercion?
I don't think it's for us to speculate on the state of Mr. Shakur's asthma and whether or not him smoking affected his asthma. The inquiry is a totality of the circumstances, and the fact is that Mr. Shakur said he was nauseous, he was wearing a hospital gown, he laid his head on the table several times, he was 19 years old, and then the detectives started saying that they can make things better for Mr. Shakur. They said things like they would reunite him with his newborn daughter, he could move on with his life. They suggested...
But they also said other things, like, I'm not going to put words in your mouth, I don't need you to tell me anything. And I watched the video, and it was, it wasn't Law and Order. They were very mild-mannered. Some of the things they said, you highlight very well in your brief, but it's undercut by other things they said during the course of the interview.
While the totality of the interrogation may not have been improper, the sheer number of improper circumstances override that. Include the coercive statements, his age, his illness. I see I'm out of time, Your Honors. Thank you.
Thank you.
Good afternoon. ADA Nicole Neckles for the people. May it please the court. Your Honor, the stop of defendant here was perfectly appropriate. The officer observed the defendant fiddling with his waistband, which the court and subsequently observed a bulge in the same left waistband that he had observed the defendant fiddling with. This court has recognized that a bulge in the waistband is a telltale sign of a weapon. At that time, the officer approached the defendant, and the defendant started to flee. He then directly told the defendant to stop. The defendant ignored that command and fled. A pursuit occurred. He abandoned the gun, which was recovered. That entire episode was completely appropriate. The officer reasonably believed the defendant possessed a gun based on the bulge, as well as the circumstances that the fact that they had been an earlier shooting only blocks away, that they were told that a large number of African American and Hispanic men were involved in that shooting. Defendant was seen walking with two men that were part of a large group of African American and Hispanic men in the area. Given the totality of the circumstances, the police had reasonable suspicion to pursue the defendant. And so we believe that there was no impropriety.
Say you counsel as to the factors raised by your adversary as to age and laying his head down on the table and other indicia of involuntariness or coercion.
Regarding the statement as well, Your Honor, a review of the entire interview, which while the clock ran an hour, really only had half an hour of interaction between defendant and the police officers, showed that there was no coercion in this interview. While at times defendant, when he was alone, placed his head on the desk, during the interview, the defendant was at all time oriented. He spoke with the officers, he answered their questions appropriately, requested water when they asked him for food, if he wanted food or drink, he responded appropriately. So there was no indication of this illness, or while he did at times, one time said his stomach felt a little upset, he did not, there was no indication that that impacted his statements and conversation that he had with the police. And we would note that this statement, by the way, is not, I should say, that statement, to the extent that there was any impropriety with it, which we dispute, really is harmless. Because at the end of the day, it goes only, the only thing the defendant admitted in that statement is the possession of the gun. And the evidence at trial showed that we had overwhelming proof of the possession of the gun. The officers testified, they saw defendant holding the gun recovered, had defendant's DNA on it, the sweatshirt recovered, which defendant does not dispute, belongs to him, had a hole that contained residue from a gunshot. So there was certainly abundant evidence that defendant possessed this gun.
Ms. Nichols, I just want to go back just to the chronology of events with respect to when the police said disperse and stop.
Correct.
So first, there is the communication to disperse. And as Sergeant Diaz is approaching, that's when he sees the bulge and he's, fidgeting, then says, police stop, and then the defendant runs.
Correct. Initially, he observes the bulge, gets out of his car, and the initial statement was, didn't I tell you guys to disperse? Then I believe defendant starts to flee and the officer says, stop. And at that point, defendant does not stop and continues to flee. And we would urge that the observation of the bulge and the other attendant circumstances was sufficient, but definitely defendant's flight escalated that from beyond our inquiry to reasonable suspicion.
Now, and there was also evidence that the defendant also fired the gun at one of the police officers. I think it was maybe Officer Garcia.
The allegation was that defendant at trial allegation is that defendant attempted to fire the gun, but really only did not, because after the initial shot went off, the gun jammed.
Gotcha.
And therefore, our argument was that defendant tried to fire it again, but did not. And we would urge, finally, if I may, just briefly on the PRS,
Just,
that.
we have your brief. We know your position on that. Thank you.
Thank you, Your Honor.
All right. Rebuttal?
Just a few points on the stop. A waistband bulge alone is insufficient to create reasonable suspicion. The people mentioned abandonment, but our argument is that that abandonment was precipitated by illegal conduct and therefore does not hold. On the timing aspect of the stop, the timing was too attenuated to create reasonable suspicion. They found Mr. Shakur 45 minutes after the reported shooting. Other cases that find reasonable suspicion due to timing do so within minutes, 15 minutes, and do so within blocks. There are no cases that account for timing when it's 45 minutes away from the report. As for the description was extremely vague and not enough to create reasonable suspicion. All they had was that they were black men in their mid-20s. Your Honors, this is the South Bronx. It was Friday night. It's an inadequate description. On the interview, there was plenty of evidence that Mr. Shakur was unable to continue with the interview. He was wearing a hospital gown. The detectives said to him, "Long night, huh?" And lastly, on harmless error, the credibility of the detectives was relied upon by the defense, and I'm sure that it wasn't harmless in determining any sort of evaluation about his confession. Thank you.
Counselor, are you here pro bono from
Yes.
Aiken-Gump?
That's correct.
Thank you for your service, and please convey our thanks to your law firm as well.
Thank you.
Thank you both. People v. Jason R. You may proceed.
Good afternoon. For appellant Jason Reyes, Jason R., I am Simon Greenberg from the Legal Aid Society. Mr. Reyes' 5-year sentence of probation was excessive because of his prospects for rehabilitation and all.
Counsel, can I just ask you, isn't this 4.5 years into the 5-year probation?
It is, Your Honor.
So he's got maybe 5 months left?
His sentence of probation expires on March 24th, 2022.
So that's approximately 6 months left, right?
It is, yes, it is. It's almost exactly 6
And he executed a waiver of appeal, correct?
Well, he executed an involuntary waiver of appeal.
Okay, but assuming that we didn't agree with that, the only way that we would look at this is through interest of justice, correct?
In order to grant us, we're asking the court to reduce his probation sentence in the interest of justice, correct, Your Honor?
And he's got 5 or 6 months. He's done it, he hasn't had any problems in 4.5 years?
No arrests in 4.5 years. He's currently working at Target. He has a full-time job. He's been working there since February of this year. He works a full shift overnight, 11 p.m. to 8 a.m., 5 days a week. And so he has a steady job, no arrests.
That's fantastic. Thank you.
Yes, we agree, Your Honor. I think Mr. Reyes is doing exceptionally well on probation. But that doesn't mean he needs to continue on probation. As we argued in our reply brief, there are strong reasons not to require someone to serve a 5-year sentence of probation. If someone is doing really well on probation, it's a total complete waste of resources for the probation department to keep supervising them when they already have strained resources and people who require much more intensive supervision than someone like Mr. Reyes. And also, there is always the risk with a longer sentence of probation that someone...
Counsel, there is good data and social science research on that topic. I agree with you. But he was facing prison time, possibly, if he was tried as an adult, correct?
He was, if
Something
he
like
were
3.5 to 15 years.
That's correct, Your Honor.
So, you know, he didn't have to go be incarcerated, and that's important too.
We disagree respectfully, Your Honor. We believe that the fact that he could have gotten prison is not really a good benchmark for judging the relative leniency of his sentence here, because you know, it's just not true that any amount of probation is just automatically a lenient sentence. He, you know, I mean, just to reiterate the point, a 5-year sentence of probation is an exceptionally long period of time that research shows is really not necessary to prevent someone from reoffending, and also carries potential pitfalls of unjust punishment, such as technical violations of probation that don't constitute new crimes. There's always a risk that someone will incur a violation of a technical nature and be punished severely for something that really isn't a new crime. And that's a very strong reason not to require someone to serve probation, even if they could have served jail time. And also, I wanted to emphasize Mr. Reyes's prospects for rehabilitation. This was his first conviction ever. The record does not show that
Counsel, what would have been the correct sentence of PRS, if any?
A sentence of 3 or 4 years of probation would have been more appropriate here, Your Honor. You know, the research that we discussed in our reply brief, shows that most reoffenses occur within the first 2 years of probation. So, you know, in a case, the minimum sentence of probation in New York is already in excess of that. So that would certainly be, you know, 3 or 4 years would be adequate, when in most cases, really, research suggests that only 2 years of probation is really what's necessary to give someone appropriate supervision to prevent them from reoffending. And again, this was his first conviction. You know, there's no evidence that he intended to use this gun unlawfully. We understand that it was a poor decision on his part, but it appears to really be a blip on the radar. And this is a young man who has strong prospects for rehabilitation. He's been doing well on probation. There's every reason to basically end his probation now.
Thank you.
Thank you, Your Honor.
Thank you.
You may proceed.
Thank you, Your Honors, and may it please the Court. Assistant District Attorney John Commendoria for the Office of the Honorable Darcel D. Clark. Defendant possessed a loaded .38 caliber semi-automatic high-point pistol in a playground. It was defaced where the serial number was scratched off. This happened in broad daylight, and cops witnessed him put it into his backpack. As a Class C violent felony, he was facing 3.5 to 15 years. If he was tried and convicted as an adult, his sentence mandatorily had to have incarceration. Instead, he decided to plead guilty, receive a youthful offender adjudication so he has no criminal record, and receive 5 years probation. There's no reason to reduce his sentence at this time, and to the extent that defendant and counsel brings up the technical violations, I would just point out over the past, I want to say 2 weeks, there was that law brought into effect where people that are brought up with technical parole violations aren't allowed to be held in jail. And while that's supposed to go into effect next year, the governor has issued an order that goes into effect now, and has been working with DOC and Mayor de Blasio so that all people held on technical parole violations are actually being released from Rikers over the next few days.
Counsel, just a question. We've heard that the defendant is doing wonderful on probation, which is a good thing. Why does it need to be continued? It's 6 months left. Why do we need to continue it? He said 3 to 4 years would be adequate. So why is 5 years necessary?
Because that's what he pled to. That was the deal he got. That this is a negotiated plea. It's not, and while I understand he is doing very well, that's sort of the goal of probation, is to keep him out of trouble and to keep him continuing doing the right thing. And since this is what he pled to, and this was the negotiated deal, and this is why he waived his right to appeal the excessiveness of his sentence and all of that, that's why it should be upheld at this time. If there's no other questions, the people do ask for an affirmance.
Thank you. Rebuttal?
Yes, Your Honor, very brief. I wanted to correct one thing that my adversary said, which is that the risk, there is still, despite the new law, a risk that someone charged with a technical violation of probation could go to prison, because the new law does not apply to probation, it applies to parole. And the issue here is not that he could be held in jail pending the outcome of a technical violation, which is what the new parole law involves. The risk here is that a judge could resentence him to prison unjustly, and that's the pitfall of technical violations for probation, which was not in any way changed by the parole law, because Mr. Reyes is not serving parole. So the fact that there's a new law in place dealing with, to mitigate some of the unfair and counterproductive problems with parole does not affect the fact that probation still continues to pose similar risks. So that was what I wanted to address. And we ask that you reduce Mr. Reyes' sentence in the interest of justice.
Thank you. Thank you both. The last case we have on the calendar today is Zhang versus the City of New York. We only have the appellant.
Good afternoon, Your Honors. I am Andrew Orenstein from Harris Beach for the appellant, the City of New York. I am very appreciative of the opportunity that you've given me to make a few points and to address any questions that you might have. The issue in this appeal is whether the repeal of Civil Rights Law 50A created a rule where, per se, personnel records of police officers, firefighters, sheriffs, etc., are to be disclosed regardless of whether that discovery is warranted as material and necessary.
Well, right. The standard now, without the repeal of 50A, results, wouldn't you agree, in the court considering whether the evidence is otherwise discoverable under the CPLR?
That is correct. But from the language of the trial court's November order, where he reversed himself, whereas he had previously determined that the very same discovery was not material and necessary under the facts of this case, and from the language of the November 2020 order.
Counsel, the law changed. So if the court decided a case under an extant law that thereafter changed, isn't the court entitled to reverse itself, modify itself, change its mind, review the case once again?
Your Honor, the change in the law, the repeal of the Civil Rights Law, was irrelevant because it didn't change the standard of discovery.
But even if that's true, though, even if that's true, the court was certainly right in granting re-argument and looking at the issue anew, right?
No, respectfully, I disagree.
Well, let's put it this way. We have the right to look at the court's determination of material and relevant. And suppose we don't agree with the judge below that this was not material and relevant to the causes of action that were pled and extant.
In June of 2020, the trial court said that the discovery of the officer's personnel records was not material and necessary.
What I'm saying to you is we're not bound by that.
No, actually, you have the authority, the ability to look with fresh eyes at
Say,
whether.
Is that right? Is that a right determination or not?
Yes, that's correct. You do have
Right.
that.
And even when the court reversed itself, we can say, yes, you were right, or no, you weren't, and it may be for different reasons. I mean, the court may have had a wrong reason for reversing itself, but we agree with the court that the conclusion that it is material and relevant to the existing causes of action is the proper determination. Can't we do that?
Yes, but the two facets to this case are this. First, the November decision creates a rule. At least it could be perceived as creating a rule.
No, it doesn't. Forget
Okay.
that. Forget that, okay?
Okay, so the,
All right.
so the standard of the CPLR remains that it has to be material and necessary.
Right.
And on these facts, it is not, without question, for a variety of reasons. First of all, the plaintiff in this case is limited to a claim under 205A of the General Municipal Law to make out a cause of action because he was in the course of performing police duties.
Well, let me stop you there, and I know I only gave you a few minutes to talk, but here's the problem. The arguments that you make on appeal here are that these causes of action or the additional causes of action to which this information may be relevant are not viable. Didn't you have the obligation to get them dismissed? And as long as they are extant causes of action, then discovery regarding them is robust.
Your Honor, discovery is often, most often, measured before summary judgment. A trial judge makes a determination. A judge in the discovery phase makes a determination what's material and necessary. It's correct that when we move successfully for summary judgment, limiting to the claims to 205A, that it won't be relevant, but this is the discovery process. Summary judgment will come in due course.
No, but you can make a pre-answer motion to dismiss, correct? And you didn't do that.
It's possible, Your Honor, but it's difficult under, as a practical matter, pre-answer motions to dismiss are oftentimes denied with leave to renew.
All right, but
In
let's
this
just say,
case-
so we have right, in this case, you didn't make a pre-answer motion to dismiss. And you have claims, extant claims, that allege a failure to train and supervise.
No,
Now,
candidly, there cannot be, because this is a
the
205A
complaint
claim.
says you negligently hired and trained this police officer, correct? Is that not a claim that is pled in the complaint?
There is, I believe, no legitimate dispute.
I'm just, first, I promise I want to hear what you say. I just want you to answer my question. Is there not a claim in the complaint that is extant that this officer was negligently hired, supervised, and trained?
Nominally, I suppose there is.
There is. You know it and I know it, okay? So there's that claim.
Right.
And
but
there's
then,
discovery that's relevant to that claim. So you did not say to the judge below, this claim needs to go out and therefore get rid of don't give this discovery.
if I may, Judge Scarpula, in June of 2020, in the original decision, the trial judge made the determination that the testimony was such that the officer did nothing wrong, that his use of force was appropriate under the patrol guidelines.
How could he have made that finding?
Well,
There's no finding of that. He opined that in the context of 50E, you know what, basically, I'm going to do this on 50E, but just in case, let me talk about a few other things. That's that decision.
Well, he did it. How he did it based on pretty strong testimony where a sergeant, the plaintiff, a sergeant of the New York City Police Department said, under the circumstances presented, Officer Longo had no alternative but to fire a shot at an onrushing pit bull, and that he did nothing wrong as measured by the standard of the patrol guide. So this is what I say when I say that a case is an evolving organism. I can't believe I just said that. It is
Like an amoeba.
the decision about discovery is made based on the circumstances as they evolve. Correct. We have not yet moved, this is an interlocutory appeal, we have not yet moved that for a judgment as a matter of law, this is a 205A claim. But there's no reasonable dispute that he was in the course of performing police duties. So my point is that he did make that determination in June, and then with the repeal of 50A, he came out with a decision that appears to imply that the documents now have to be discovered because of the repeal. He said, and this is in the record at page 7, through with my fog and my glasses, in light of the repeal of 50A, these records are not only discoverable in court proceedings, but are subject to FOIL. That is, quite frankly, an incorrect statement. It is an incorrect rule of law. Now, he said a lot of things here, and I don't mean to take it out of context.
Right, they are subject to FOIL. That there's no question about, right? If somebody made a FOIL request for them, then it's, but that's not what we're talking about.
Right. The Court of Appeals has said that FOIL is very much different from the discovery statement.
Agreed.
That's right. So,
Counsel, you skipped a procedural step. You're asking us to close our eyes and say, okay, poof, you get your wishes granted, but you didn't do what you needed to do. Not you personally, of course.
well, there are two issues here, and we're asking for relief with respect to both. The first is that the November order, which I can't say this is an issue of first impression. I'm not aware of this having come before an appellate court, appellate division yet, but this will be perceived as creating a rule that, some will see it this way at least, that because of the repeal of 50A, where you have a police officer or a firefighter or a sheriff or a correction officer, that the personnel records come in, that they're discoverable. Because the trial court said that the City of New York's objection to disclosure of these records are unavailing and more appropriately deferred to trial. That's an incorrect rule. The rule remains that it has to be material and necessary to the claims. So,
and I don't think we disagree with you, but
that's
it's what we say that counts.
Well, that's my point. We're looking for two things with respect to this appeal, which is why we felt it was so important to argue. First, we need an appellate division statement of the correct rule that corrects the misimpression of this order. And second, we think it was an abuse of discretion to order the disclosure of the personnel records in this case, because all that matters in this case is what Officer Longo did at the moment, is whether his use of force was reasonable. So the second ask, we ask that you reverse the order and suppress the direction that the records be produced in this case. Did I make myself clear?
Very.
Okay.
Very. All right, any other questions?
I just have one question, and I'm going to keep it brief because I know everyone's tired. What happens if the plaintiff brings in an expert that says this wasn't in the scope of his duty, and that he was negligently trained, and that for that reason he should be held personally liable? I mean, with that claim extant, that's not an impossibility. The fact that the judge below said, this is what the testimony was, yes, it was, but that's not tested on a motion. That's not found to be undisputed. It wasn't, my point is, you're saying it's undisputed, but it's only undisputed because no one tested it.
Your Honor, that's exactly my point, because there is no predicate for a 205A claim that is properly pled on these facts that would allow that to happen.
So why didn't you move to dismiss it, is my question.
Because
If
we're in a
you're saying that as a
situation,
matter of law, that claim had to go, then why not make it clean and move to dismiss it so we don't have to make a proclamation about an otherwise extant claim?
I'll take responsibility for that, but the fact remains that the rule expressed in the November order is incorrect, and on these facts, you know, an issue that I haven't raised, and the red light's been on for quite some time, is that it wasn't appropriate to grant renewal or re-argument at all, because there is no change of law that affects the determination of this case. There was no change of law under the CPLR discovery standard, and there were no new facts that were available, that were not available to the respondent. What I'm saying is that it was inappropriate to even grant renewal or re-argument. And that is a basis for this court to reverse the order in and of itself.
Okay, thank you.
Thank you.
Thank you, gentlemen.